Yes.
But subject to losses. One matter blood that for streaming of resource. The matter was appearing in the list of losses. It has gone out of
Huh?
streaming of
My lord,
I have
my matter is going out of list. How it is possible?
Yes. Which matter?
that framing of resource blood.
My lord, suit number 250.
In the last week, but it was in the list, but now it is not appearing.
My lord, my matter should be heard first.
Much obliged.
My lord.
Yes.
My matter number 2, CS 250 of 211 is out of the list. How it is possible?
Out of the list?
Yes.
Okay, it will be listed tomorrow. No problem. It will be listed tomorrow.
I have also requested your lordship about the Supreme Court direction made in 2021. We request the High Court to dispose of the suit extrajudicial considering the fact that the prisoner is a senior citizen. My lord, it should be listed in the prior list.
Correct. Tomorrow it will be listed as to be mentioned. Be present tomorrow and please give the case number. The
250 of 211.
252 of
11.
2007.
11.
Okay. 11 मेरे पास है. Okay, come tomorrow. It will be taken up tomorrow. But what are the Supreme Court judgment? You are having any person here who can give the copy of the order of the
copy of order is already submitted before your lordship in the supplementary reply.
Okay, I will see to that.
May my lords kindly Millard to mention two suits, Millard CS 6 of 2024 and C8 of 2024 non-commercial Millard. This is Millard where Millard had restrained the transfer of sharehold Millard shares Millard Motilal Oswal.
Then make it simpler. I was supposed to give my affidavit in operation by last Wednesday. Gives me a little more time. On Monday, I'll give it to him.
Millard, let it appear tomorrow as to be mentioned because otherwise I cannot. Millard, time has already expired long back.
When you will give the copy?
On Monday, Millard also.
Okay. My time gets reduced.
Non-commercial.
It's a non-commercial. Tomorrow is the last date.
Do one thing. If you give the Monday, let the matter come on Tuesday.
Great.
Come on
Tuesday, Millard commercial.
Wednesday. Come on Wednesday. In the meantime, if you give the copy, receive the copy and come with the.
Only I'll give it.
Then if required, I will extend the time for reply.
Very well. Millard, only difficulty is that Millard, the matter Millard had fixed at 3 p.m. on 13th of March. Now, Millard, my time gets reduced automatically. Now, Millard, I also don't want
hearing.
Yes, Millard, I also don't want Millard that matter to be shifted to any other date.
That's why he's telling that. That's why telling that you will supply the copy on Monday. I am fixing on Tuesday, Wednesday as to be mentioned. Let me see. If it is supplied, then I will extend the time for reply. No problem.
Great. I will file within that time, Millard, so that it can be correct. Date is not shifted. Millard, these are the two Millard.
Wednesday.
Grateful.
To liken in
Wednesday.
Yes. May I mention, Millard, one matter in this matter, Millard, I am for the plaintiff, Lordship. Mentioning upon notice, Millard, written statement filed by the defendant, Millard. Your Lordship, Millard, kindly allow this matter to be appear under the heading, Millard, to be mentioned.
For what?
For the matter further order.
Written statement is accepted?
Yes.
There is no counterclaim?
No, Lordship.
Who is for the other side?
Mr. Shantan Bosch.
Huh?
Mr. Shantan Bosch.
Sayatanbur, yes. So what you want now?
For the
direction.
Yes. For the
discovery inspection.
And Millard for filing of.
The commercial or non-commercial?
Non-commercial, Lordship.
Booth ko kar do. Thursday kar dijiye.
Lordship, may I have your kind leave to mention one matter? This is PLA 148 of 2021. This is for correction. There is a date that has gone wrong in the order. Much obliged.
My lord, may I have Lordship's leave to mention?
Order kahan hai? Where is the order?
Lordship, it's the order. It's the last.
Where is your order? Where is the order?
Sorry.
Yes.
May I have Lordship's leave to mention this matter? My lord, this is relating to Calcutta swimming club matter. Your Lordship was hearing yesterday, my lord. I've taken out a temporary application, my lord.
Which one?
Calcutta swimming club matter. Your Lordship was.
No, I am not allowing you. File it.
I've already, your application is ready, my lord.
Sorry.
It will be listed tomorrow, my lord.
File it. No.
May I have kind leave to mention? May I have kind leave to mention, my lord, item 20 of release dated, my lord, 10th of February. My lord, this is an application. 10th February, the monthly list. It was in the list, daily list. This non-commercial shoot. Your lordship has already allowed this route, but this, the admission has been given. The interim order, the applications are pending. But this is appearing at the item number 20 of 10th of February's list. Let it be taken up because the
10th of February list. Today we are on 12th.
This was appearing in 10th of February monthly. It was not taken up. But the applications, the dependents are taking benefit of this. There's interim order is not there at all, but this has not been taken up at all. But they are entering into the agreement with the other parties. These are partitions admission suit. They are entering into the other parties to sell out this property. Your lordship has already admitted the suit. This is any day your lordship is
For what?
applications.
For what application?
Application for injunction and appointment of receiver.
Have you filed?
Yes,
Have you served?
this is appearing in the
Okay,
list dated.
appearing it.
This monthly list, that's why this is the problem. Your lordship, only 2 days that lordship is taking up the non-commercial matters. This is not coming. This is very urgent. Your lordship, anything.
Every matter is urgent.
Your lordship, there is no injunction as your lordship has not taken up.
Either from the
So,
dependent side or
dependents are taking the advantage of
if
that.
I will allow your urgent matter, tomorrow he will come with the urgent matter.
These are
Day after
applications
tomorrow
as your
he will
lordship
come
has
with the urgent matter.
as your lordship has
When
not.
the plaint was admitted, why you have not filed the injunction application?
That is along with that, that was not taken up.
You not mention on that day.
This is
Once I
appealing,
find that there is an injunction application at the time of admitting of the suit, on the very second day I am taking the injunction
I know,
application.
the pardon any day your lordship as your lordship.
Any day that then it will come with the list.
But this is appear, but the daily list. It's.
Have
should
you
be
informed the other side by mentioning?
This is not because I have not yet served because this is ad
First you
interim.
told that you have
This is on
served.
ad interim stage. Your lordship kindly appreciate this. This is an ad interim stage, my lord, your lordship.
It has taken.
My lord,
May I have your
much
lordship's
older.
kind leave and bring for inclusion of a probate application on constitution.
May I have your lordship kind leave to mention matter. I am mentioning on upon notice. I have instruction to withdraw this suit, my lord, for the plaintiff.
Commercial, non-commercial?
Commercial matter.
Commercial.
Yes, my lord.
Defendant in this matter. So I was telling him, got very disappointed. The client yesterday came for a conference. He is withdrawing the suit now.
You two did just answer that he can.
My lord, actually, I have
Always for the clients to see.
earlier also we have mentioned that the person who were acquainted
Friday
with
to
this.
be mentioned for withdrawal.
Master Blaster.
It is commercial matter?
Yes, my lord.
Friday.
Yes,
Friday has to be mentioned for within bracket withdrawal.
Grateful.
Master Blaster.
May I be permitted to mention one PLA matter, your lordship? There was a direction for citation, and after such, all other completies have been complied with. The matter is ready for hearing. Your lordship kindly takes up the matter.
Have you got the citation issued?
Yes, your lordship.
Obtain the no caveat certificate?
Yes, your lordship.
Give the number.
Well, the same prayer for inclusion.
You PLA, give my court officer.
Lordship, may I permit to mention one matter? Section 34 application of Indian trust matter. There was a GA application I have filed in 2024. Lordship, there was a order passed by the Honorable Justice Bobby Shekhar Sharif. Lordship.
Which year?
Saraf, Lordship. Justice
year?
Saraf.
Justice Saraf, which year?
In 2021. 2021, Lordship.
2021. Now what is the urgency now?
There was a building, Lordship. In the trust property, there was a building. There was.
What order is passed?
May I hand it over the order, Lordship?
November 2021, the court has directed you to publish the notice with regard to the sale of the property after obtaining valuation.
We have complied the
When
order,
you
Lordship.
complied?
In that
2021.
Yet,
Now we
Lordship,
are on.
when
After 3 years
2025,
of what
Lordship,
the valuation has been
now the
decreased or
client has
increased.
client has come now, Lordship. There was a
The client is not having urgency. Why you are mentioning the matter?
kindly, Lordship.
2021, the court has passed an order for publication of the notice after completing the valuation. 2020. Now, what would be the valuation as on date today? Can you act on the valuation of 2021 and 2025? Then you have to again obtain the valuation.
Yes, Lordship. But
So what you want now?
now there was a selling permission, Lordship. There was a
sale permission. The court has initiated the process, but you had delayed the matter. So I am asking a question to you, the market valuation, the property of the market value or whatever it may be. Can you relied upon the market value of 2021 on 2025?
Then we have to reevaluate it, Lordship.
Correct. You obtain the revaluation
we have-
certificate and come.
We have obtained, Lordship.
Obtain. When you
Lordship.
obtain?
The date was not exactly, I recall, Lordship. Kindly include it, I will be.
Yes, next.
Your Lordship, I pray for your kind leave to mention this matter. It is a testamentary suit of 2023 for inclusion in the in your Lordship's
Give it
list.
to my court officer.
Great.
Yes.
Your Lordship.
My lord, may I be permitted to mention a few cases which are pending in the monthly list and are
Every
not.
case is pending.
I am praying for fixing a date and time as may be convenient to my lord.
You are ready for the March?
Yes,
March
yes,
last week or April first week?
my lord. March earlier in just
It's
earlier.
the suit, but I filed my written statement. No point fixing the matter for at any time.
What application you want to hear this court?
These are mentioned here.
কতগুলো suit mention?
6-7 cases. These are
I will
appearing
do
on the-
one thing.
Yes,
If
sir.
1, 2, 3, 4, 5, 6, 7, 7 cases.
Yes, my lord.
Every Saturday, I will take all matters.
Every Saturday. I
Every
am
Saturday.
obliged. I am obliged.
I'm not obliged, my lord.
I am the appearing counsel. Please do not, Miller. But yes, Miller, truly,
He's ready.
truly,
Yes,
ultimately,
he is my counsel.
ultimately, Miller, there are some matters which have been lingering, Miller, at the final stage of
What
the
is the
appearing of the
stage?
hearing. Miller, your lordship may kindly, Miller, as per your lordship's Miller convenience.
The final
keep these
stage, I do
matters,
not know, my lord. I filed my written statement. Nothing else has
No,
happened in
then
the suit.
we are
my lord.
mentioning 7 matters.
One of it.
As and when, Miller, if your
appearing.
lordship can
See,
keep
one
it.
matter is the witness action. 3rd
Yes.
April already fixed.
Yes.
3rd April 2024.
Yes,
Correct.
Miller. Yes, Miller.
And what about the first matter?
Miller,
27 June 2024.
yes.
What has happened to that? What is
Miller,
the stage of that?
Miller,
Yes.
this is also, Miller, should appear under the heading, Miller, to be mentioned so that, Miller, we can determine the future course of the suit. Some of the matters are also there, Miller, where written statement has not been filed.
Is it commercial or non-commercial?
All are non-commercial. All are non-commercial.
All non.
May I beseech your lordship, Miller, to fix these matters under the heading to be mentioned so that we can, Miller, determine what
You are
is the
appearing
state.
for all matters?
No, my lord,
for
only
Gyan
one.
Nidhi
CS 89 of 2021, and that's serial number 4, my lord.
Yes.
Item 242, I'm appearing for the defendant.
Ashok Chaudhary is appearing.
No, that is
Thereabout is not there.
that is the reason why, Miller, we
No.
beseech your lordship to kindly fix this matter under the heading to be mentioned so that, Miller, the next course of the suit can be
On
determined.
notice. On
No,
notice.
that is fine. That is fine.
Okay, you issue the notice to all the defendants.
I have
Done,
already.
done, done.
I am fixing on 26.
Yes.
26 to be mentioned.
I'm deeply obliged, Miller.
obliged.
The last item
337,
my lord.
Nothing
is due and payable. The principal amount has been paid. Okay, let come on that day. We'll see.
We will clarify those issues, Miller, and the
Come
suit
on
will
that
proceed.
day. 26 I am fixing as to be mentioned.
Yes.
Issue the notice and we'll see to that. Oh, 26 और कोई matter मत रखना ही रखना. To be mentioned.
Again,
Yes.
I have to
I'm
issue
deep-
notice to all.
Yes, yes.
26.
Informing that 26 it will be listed as to be mentioned.
I'm most obliged, Miller.
Yes.
My lordship, I beg to mention a originating summon matter. My lordship has asked for the order to.
What order?
Last order was passed. The service was made. 2 person is deceased, my lord. I beg to file also a substitution application, my lord.
41. Determination.
So summons has been issued.
Summons has been issued, my lord.
Have you obtained report?
I have obtained report, my lord.
Appeared anybody has entered appearance? When the summon has been served? When the summon has been served?
Summon has been served on.
Where is your report?
My lord.
নেবে তো?
This is report from the department. This is your affidavit. Report from the department whether the defendant entered appearance or not. Obtain report and come. Correct.
My lordship, if the direction is given to the department to issue a report.
You are practicing in the original side?
Yes, my lord. Oh, my lord, pardon.
Yes.
My lord, may be permitted to mention testamentary matters, my lord.
Yeah.
Lord, may be indulge one in more indulgence, my lord. On last occasion, I mentioned, my lord, PLA 89 of 2024. It is to be appear as to be mentioned, my lord. Can it appear on 21st? Because I have an operation tomorrow, so I will not be available. to be mentioned 89 of 2024.
So what has happened on 21st?
No, it has. I have mentioned it to appear as to be mentioned.
Yes, call the list.
Why not mention virtually? The testamentary ready matter 122 and 134, my lord. My lord, I have mistakenly mentioned the matter.
Call the matter. Call the matter.
My lord, testamentary.
But we are for the defendants, madam. Defendant.
GS7 is allowed, CS is dismissed as not maintainable.
Diploma.
Item number 2. I am for the plaintiff petition.
No. GI is dismissed.
Number 3. I am for the dependent petitioner.
This court find that the suit is commercial in nature. According, the plaintiff is returned to the plaintiff with the liberty to file before the appropriate court.
Item number 4.
I am for the petitioner, my lord.
Wrap you for the defendants.
GI dismissed.
I'm grateful to Lordship.
I am for the petitioner.
Yes, just to check করুন এখন নিরাপদ দেখেন আমরা কি ঠিক আছে
Yes.
I appear for the executor. Your Lordship had revoked the grant of probate, and now this has to be treated as a contentious cause. He has filed his affidavit in support of caveat, so that may be treated as a written statement. Lordship will pass orders for discovery and inspection of documents.
My lord, I leave it to your lordship, but the procedure remains that they must come off because the citation has not been official, because there are other legal layers upon whom the citation is required to be served.
And whoever has filed affidavit in support of the caveat has to be treated as a written
Because
statement.
there is no caveat served upon us. That is why, my lord, affidavit, my lord, the caveat citation since not been served, my lord, the filing of caveat and support of caveat affidavit, my lord, there is no direction, my lord. That cannot be, my lord.
But the citation, that is the ground on which Lordship has revoked the grant.
There are
Now
several
the
legal
affidavit
layers.
is there.
There are several legal layers upon whom, my lord,
But
the
they have
citation
to
is required
come.
to be served.
They have to come. This is a contentious
That
cause.
is
It's
not
a
the procedure,
question
subject
of
to your
question of
lordship's, my
veracity
lord.
of the will. Now this is a testamentary suit. Now Lordship will treat it as a written statement as it is done. But
Have you filed the caveat? Affidavit in support of caveat?
No, my lord, I could not, my
yes,
lord.
but,
Initially, my lord, I filed my application for the revocation of the grant.
Correct.
But that is there. My lord,
not
subsequently
affidavit.
it has been revoked, and the matter as it is, it was there. So, my lord, the filing of, my lord, the caveat or in the affidavit in support of caveat, my lord, does not arise, my lord.
But the
I leave it to your
revocation.
lordship, my lord. There are
No,
other legal
see,
layers also.
That I will see to that.
My lord, my
Now
lord.
you are appearing on your prayer.
On
This
behalf
has
of one
been
of the legal layer.
one of the legal it will
My lord.
restored. Whether
My
you have filed the affidavit in support of caveat or not.
I did not.
So you
my
could have been filed because if it is when the order was passed January 15.
But the application for revocation can be treated as a written statement. All the grounds are there.
Say that is
lord. No, my lord. There are other things which I need to.
Yes,
be brought
additional
into- there are
grounds.
How soon? You tell me. How
Three
soon you will file?
3 weeks, my lord. Because
Law
my lord, there are
provides-
certain documents.
Kindly, my lord.
Law provides
May I
8 days.
explain, my may I explain, my lord? There are certain documents which contain the signature of the testator, which squarely difference that of the will.
That's correct.
I need to bring all those things, my lord.
That you have to bring on by
3 weeks time, my lord. 3 weeks time, my lord.
I am
15th
giving
of
2 weeks time. I am giving
15th the order was passed.
Ah,
Today they have
1 month has
One month.
passed.
my
1
lord.
month is passed. You
1
not
month is
taken.
passed.
You could have been taken steps for filing the affidavit, but they have taken the step mentioning the matter. You could have been taken the steps. Once the
Make it 3 weeks, my lord. BCG lords.
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petitioner submitted by an order dated 15th of January 2025. This court, by allowing the general application, allowing the application being GA number 1 of 2024. नहीं, क्या बोला? This by an order dated 15 January 2025, this court has revoked the probate granted by this court and restored the PLA number 164 of 2022 in its original file. Accordingly, counsel for the plaintiff submitted as the caveator, as this court on the prayer made by the caveator has revoked the probate. Thus, the suit is to be treated as testamentary suit and to pass appropriate order for discovery and inspection of the document. Per contra, an advocate appearing for the caveator submitted that though he has filed an application for revocation of the leave and revocation of the probate, and this court has revoked the same, but the caveator has not filed affidavit in support of caveat and he pressed for 3 weeks time to file affidavit in support of caveat. Considering the above as a matter of last chance and for the interest of justice, the caveator is granted 3 weeks time to file affidavit of caveat in support of caveat within 3 weeks from date. Let the matter appear on Let the matter appear on 12th of March 2024.
Wait, March 21.
But I appear for the petition.
Yes.
Your Lordship had granted me the letters of administration, my Lord, by order dated 3rd of December 24. I find, my Lord, there is an office report.
Yes, there is an office report. I am giving this office report by so causing the petitioner as to why the probate order of probate cannot be recalled. And the report will be supplied to you.
But
there are 3-4 lacunas are there. I am giving the first of all the witness, the legal heirs.
My Lord.
The address of the legal heirs in the Aadhaar card is different. You have sent the this notice to the legal heirs in a different one thing. Second thing, the testator's identification has been done by the same witness.
My Lord.
Correct. And 2, 3, and I am serving the copy to you. It has been recorded in order. The matter is listed as to be mentioned on the report on receipt of the report of the Registrar Original Site dated 10th of February 2025. By an order dated 3rd of December 2024, this court has granted probate, has passed an order for grant of probate.
These are my mistakes.
Full stop. While the department has processed for grant of probate, issuance of probate in terms of the order dated 3rd of December 2024, the department on its scrutiny of the record have found several anomalies. Accordingly, the Registrar Original Site has submitted the report before this court. Full stop. This court finds that before passing any order, an opportunity is to be given to the petitioner to show cause as to why the order of probate granted by this court dated 3rd December 2024 shall not be recalled. Full stop. The copy of the report dated 10th of February 2025 be served to the petitioner. Full stop. The petitioner is directed to show cause within a period of 2 weeks from date. Let the matter appear. Let the matter appear on 2 weeks. Na?
But only one indulgence for it, if it can be 3 weeks, because the advocate and record
within 3 weeks. Within 3 weeks. Let the matter appear on 13th of March 2020.
Great.
Okay, copy आज दे देना. Take the copy.
I'll tell ma'am.
For the petitioner. On the last occasion, your Lordship directed to file a report by the IT department as to why the matter is appearing is disposed of.
Yes.
Well, the matter is more or less ready, my lord, can pass order. The matter is ready, my lord.
So appearing for the petitioner. The matter is listed as to be mentioned on receipt of the report of Register IT dated 6th of February 2025. The matter was taken up for hearing on 29th of January 2025, and on the said date, it was informed by the learned advocate appearing for the petitioner to this court that in the website, the status of the PLA number 105 of 2023 is shown as disposed of. Accordingly, this court, by an order dated 29th of January 2025, has called for the report from the Registrar IT. Full list. In compliance of the order, the report has been submitted. Consider the report submitted by the Registrar IT. Full stop. The report is accepted. Full stop. The report is accepted. Full stop. The PLA number, the Registrar IT is directed to delete the PLA 105/2023 in the list of disposed of matter and to place the same in the list of pending. List the matter before this. List the matter on 19th of February 2025.
But can it be 21st? Because
21st. Okay, 21st.
I have an operation, so 21st. Get full.
I pay for the plaintiff. A date may be fixed for witness action. Issues have been framed. I am for the plaintiff. Contested. They have filed a written statement. Issues have been framed. Any date, subject to my lord's convenience, so that I can bring my witness.
No, Commissioner.
Can be done, my lord. Huh? No. My lord, any day in court, my lord.
So appearing for the plaintiff. So. No, none appears for the defendant.
None appears.
Have you informed that? Mentioned?
It is contested, my lord.
No, to mentioning you have mentioned that.
Mentioned on notice is appearing in the list also.
So appearing for the plaintiff. The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. Counsel for the plaintiff submit that by an order dated 11th of September 2024. This court has framed the issues and directed the parties to file judge's brief or document within 2 weeks. Have you filed the judge's brief document?
It's ready, my lord. I'll file it, my lord. I want to have a look at it. It's ready.
For the plaintiff submit that the plaintiff will file the judge's brief document within a week from date after serving the copy to the learned counsel for the defendant and prays for fixing the matter for witness action. In view of the submission made by the counsel for the plaintiff, let the matter appear. Give the date. 26 of March. 26 what क्या date क्या है दिन क्या है 26th of March
deeply obliged
2025 at 3 p.m. for witness action.
I'm deeply obliged.
The plaintiff is directed to inform the next communicate this order to the learned advocates appearing for the defendant.
I shall. I'm so deeply obliged.
For the respondent, your lord.
My lord, I am appearing on behalf of the plaintiff in this matter, my lord.
Why mention?
GA2 is an application under section 8. My suit is for, my lord, cancellation and delivery up of a document which according to us is my lord, a forged document. So GA2 has been taken out because in that forged document there
Who has filed the GA2? You.
The defendant.
You are for the plaintiff.
I am for the plaintiff.
Yes.
GA1 is my application for injunction. Now, my lord, GA2 is taken out by the defendant to say that there is an arbitration agreement in the forged partnership deed, which according to us is forged. And GA2, my lord, is now pending hearing for quite some time, almost 1.5 years, if I am not incorrect. GA1 was not taken out, could not be heard because GA2 came in the picture.
What is the ground of the GA2?
GA2 is
what is the ground for dismissal?
GA section 8.
11,
section 8.
Okay.
Now, my lord, in this meantime, what has happened? There is, my lord, a parallel proceeding going on before the arbitration court. Section 11 filed, direction for affidavit, that is also running in the list. Now, there was some time taken by my learned friends, my lord, client to file
the section 11.
Section 11 filed by the defendant. According to them, there is an arbitration clause and there is an arbitrable dispute. According to us, the court has full jurisdiction because the document is completely forged. We are also fortified by one of your lordship's recent judgments, which says that when there are, my lord, egregious fraud committed in the instrument itself, arbitration is not the correct recourse. In this circumstance, my lord, they are proceeding with the section 11. That is creating determinant to our suit, because if an arbitrator is appointed, then, my lord, my entire suit becomes infructuous. So, my lord, they have taken more than 6 months' time to file their affidavit in reply. They say that their client was unwell. I accept it. My lord, today they will be filing their affidavit in reply. Let it be understood that, my lord, we would be giving some time to the suit for hearing of section 8. If section 8 is decided and determined, then I will not have anything to say.
Section 11 be disposed of.
But that
Instead
section
of
11, my lord, your lordship is aware.
Because section 11, you might have been filed affidavit.
Yes. The scope of section 11, my lord, is very slim. Now, with all the recent judgments of the Supreme Court, even the one coming up
Even section 8 also.
Yes, but your lordship, my lord, will have to, my lord, perhaps take into consideration my pleadings in the plaint. It's a forged document. No one is having the original of it. That's the admitted case. No one is having the original.
The arbitrator will decide.
My lord, what I was only saying, fix a date, fix any date, fix any time. Let it be understood between the parties in all fairness that
now what you want?
Any date and time, my lord,
of hearing of J2.
Of hearing of J2.
Yes, Mr. Katari. You are appearing.
Your Lordship will recall, yes, Your Lordship, I am for the respondent. Your Lordship will recall, Your Lordship had granted me leave to get it affirmed from since my client was in hospital, just to get it affirmed by the affirmed and notarized. My Lordship would grant me leave to file it with Your Lordship. May I file my affidavit and reply my there in court with the affidavit and reply, and Your Lordship may fix a date for hearing.
I will fix the matter for hearing. There is no problem.
Lordship, but we'll fight it out, Your Lordship. There are judgments which states in my support as well, Your Lordship.
Okay, he wants it to be heard. Lordship will fix it, my lord. But let it, my lord, be also recorded that they are filing a notarized version pursuant to the.
Have you disclosed in the section 11 application? Section 8 is pending.
Yes, yes.
Lordship, they have not filed in.
Suffering for the plaintiff, suffering.
This matter is there in the list. Is not.
Counsel for the defendant has filed an application being GA2 of 2023 under Section 8 of the Arbitration and Conciliation Act 1996, praying for referring the parties to the arbitration in terms of clause available in the agreement. Full stop. Counsel for the defendant has filed affidavit in reply in connection with GA2 of 2023 after serving the copy to the learned counsel for the plaintiff. Let the same be kept with the record. Counsel for the plaintiff prays for fixing the matter for hearing in connection with GA2 of 2023. Full stop. Let the matter appear on. Give the date and time.
My lord, may it be your lordship's pleasure, my lord, to note that this is a notarized copy.
That
and the reason, my lord, behind it.
That I think.
No, it has to be.
The affidavit in reply filed by the defendant in connection with GA2 of 2023 is being notarized before the notary public in as per the leave granted by this court.
And my lord, one humble submission, let it be understood between the parties that the date and time fixed, which will be fixed by your lordship's court, we will be honoring that and we will be moving the section 8. It's their application. In the meantime, my lord, we may not proceed with the section 11 because both. I'm only saying.
I object to this.
My humble submission may be recorded. That is what I am saying.
I will not record
anything. Let it be understood.
Your Lordship, section 11 is being taken up by a coordinate bench. Your Lordship, by Lordship's order, can't stay the hearing of the section 11 of.
Let the matter appear on.
Let it be understood that we will not be proceeding with the section 11.
24th March, 3 p.m.
Grateful, Your Lordship.
I'm deeply obliged.
Yes, next.
My lord, the suit has come at my instance, my lord. The defendant has been served with the summons, my lord, in August 2024. Till date, no written statement has been filed, my lord. May I hand up the certificates, my lord?
My written statement is ready, but some documents are yet to be applied. The 30-year
my lord, this is earlier there was a suit, my lord. It was in commercial division. That took a point that the suit is based on the notice 106 notice. It is not maintainable in commercial division, my lord. We have filed a regular suit, my lord. Now, someone was served in 2024 August, my lord. Till date, no steps.
I agree, summons have been served, we entered appearance, but till date, my lord, we have not been able
We have
to
not
file our-
intimated even as
Yeah,
to
you
when.
take steps, no problem.
Well, I will file a formal application for next.
You take steps, but as on date, there is no written statement. 90 days, 120 days is over.
And no explanation as to why.
I will come up with a formal.
Come with a formal application that will be taken up for hearing, no problem.
My lord, we kindly place the suit in the undefended list, my lord.
Well, this is
And fix date and time. Doesn't matter.
Non-commercial suit. Show me non-commercial suit. There is no binding.
There is unlimited time, my lord.
Suffering for the plaintiff. Suffering for the defendant. The matter is listed on behalf of as per the submission made by the counsel for the plaintiff. Counsel for the plaintiff submitted that the writ of summons
was served, my lord, in August
was duly
2024.
served upon the defendant through the bailiff on 21st of through the bailiff as well as the postal service on 21st of August 2024. But in spite of service of writ of summons, till date, the defendant has not filed written statement. Counsel for the plaintiff has handed over the service report issued by the Deputy Sheriff of Calcutta dated 30th August 2024 and the report of the Deputy Registrar Legal dated 6th of February 2025, wherein it reveals that the writ of summons were duly served upon the defendant on 21st of August 2024, but no written statement on behalf of the defendant has admitted with the office of the London Master till 6th of February 2024. Considering the submission, full stop. Counsel for the defendant submitted, the defendant will take appropriate steps for extension of time to file written statement. Considering the submission made by the counsel for the respective parties and the report submitted by the learned counsel for the plaintiff, this court find that the writ of summons has been served upon the defendant on 21st of August 2024, but till date, the defendant has not filed the written statement. Accordingly, let CS number 151 of 2024 be placed in the list of undefended suit.
My lord, kindly indicate a date and time, my lord, so that I can ask my witness to come.
This is the matter. Full stop. The plaintiff is directed to file the judge's brief of document within 2 weeks from date. Full stop. This is the matter. On give the date. 27 March 2025 at 2 p.m. for witness access.
Leave be granted, my lord.
Leave cannot. You file an application, come, we'll see to that, sir. Not leave is required.
No application till date, my lord. No steps.
For witness action, that's why, my lord.
You file an application before that. We'll see to that. Yes, next.
Please, my lord.
Yes.
My lord, this is that matter where when we were seeking reconstruction of the trust. This is that matter, my lord, where we were seeking reconstruction of this of the trust. There's a note from the master wherein an amendment is to be moved. This has to be a case of originating summon, which is to be renumbered as CSOS. So the matter is appearing in the list at my behest, my lord. I mentioned it.
What you want now?
My lord, at this point of time, seeking leave, I cannot move an application because the suit is not yet presented. So I beg my lord to grant me leave to file afresh. Let me withdraw the suit.
The suit with the liberty to file afresh?
File afresh with the same court fee, my lord.
So and so appearing for the plaintiff. The matter is listed as to be mentioned on the submission made by the counsel for the plaintiff. Counsel for the plaintiff submitted. There is some defects in the plaint filed by the plaintiff which cannot be cured by way of amendment, and as such, the counsel for
my lord, amendment cannot be moved at this stage because the suit is not yet presented.
Plaint and filed by the plaintiff, and the plaintiff cannot move amendment application at this stage as the suit has not been admitted. Why the number has come if it is not admitted?
It is filed, my lord. Admission comes only after filing.
Not admitted. Not admitted. Counsel for the plaintiff prays for withdrawal of the suit with the liberty to file afresh on the same cause of action with the same court fee. But the learned counsel for the plaintiff
Court fee to be withdrawn by the advocate on record as per
Plaintiff,
application.
the plaintiff is given liberty, full stop. Given liberty to withdraw the suit with the liberty to file a press. Accordingly, CS number 192 of 2024 is dismissed as withdrawn, liberty to file a fresh on the same cause of action, full stop. The department is directed to refund the and to utilize and to refund the court fee to the plaintiff to utilize the said court fee if the plaintiff intends to file a fresh.
Much obliged, my lord.
Well, I'm for the plaintiff, not a suit for defamation.
Suit for?
Defamation. I'm
So why
seeking
it has come here?
for presentation of plaint. I'm seeking leave under clause 12. Although sole defendant is within jurisdiction, I don't practically need this. But part cause of action has arisen. Defamation suit. He has been spreading incorrect statements against us, my clients, both outside and within. So for abundant precaution, I have played clause 12. That leave lordship will grant and then will
Decree for 100 crore.
But that's
inquiry we made.
that is
when the publication was made.
No, October.
October 24.
Well, my application, lordship, give me the leave to move it on next week.
What
Tuesday.
application?
Or injunction.
Interim.
Injunction.
Sensation supreme for the plaintiff. The plaintiff has filed this suit for damages. Plaintiff has also prayed for leave under clause 12 of the latest patent 1865 on the ground that part cause of action arose within the jurisdiction of this court and part cause of action arose out of the jurisdiction. Consider the submission made by the counsel for the plaintiff, peruse the pleadings in the plaint. Leave under clause 12 of the latest patent is granted. Plaint is admitted subject to scrutiny by the department. Counsel for the plaintiff submit. The plaintiff has also moved an application to a grant of interim order. Let the said application be placed on
next Wednesday.
On 19th or 20 February.
One more thing I should point out, that in paragraph number 39 of the plaint, I have pleaded for leave under order to rule 2, but that mistakenly that has not gone into the prayer. So for that is why I formally not thought that. But I
am not granting anything.
But I have to show me that pleading is great.
14 my lord, I'm for the plaintiff, my lord. This is suit for recovery of money granted on loan to the defendant, my lord. The defendant number 1 is a partnership firm and defendant number 2 and 3 are the partners of the firm. But the defendant was a tenant of one of the properties in Odisha of the plaintiff, my lord. What has happened? There was a cordial relationship and they had asked for, the defendant has asked for a loan of...
When you made the payment?
In November to December 2022.
2022?
Yes, my lord.
When the last payment was made to you?
And in 2022, December 2022, my lord.
December 2022?
Yes, my lord. On December 2022.
He has written, paid the...
But I have the bank statement. I have the bank statement. Starts from page number 12. There was 2 bank accounts of the plaintiff. From there, the money was transmitted to the defendant. 3 crore 24 lakhs 50,000 was paid. 1 crore 50 lakh 50,000 from one bank and 1 crore 74 lakhs from another bank.
They have not paid any amount to you?
No amount has been paid. There was an agreement that for 6 months we will not take any interest. We have not done that. After 6 months, we have levied interest and sent a demand notice. The demand notice appears at page 17. The defendant is outside jurisdiction and the part cause of action arises outside jurisdiction. That is why I prayed for leave under clause 12, the latest bit.
How part cause of action within? And how part cause of action outside?
Money has been debited from the account of the plaintiff that is within.
Yeah.
Yes, my lord. And the amount is but I am also filing an injunction application. That
for what?
But for not
money, what injunction?
Chapter 13A application, my lord. There, not to operate the bank accounts, my lord. To keep, I have the bank account of the defendant.
Supreme for the plaintiff. Full stop. Full stop. Concept for the plaintiff has filed the present application, filed the present suit, praying for decree for a sum of rupees 4,24,09,500 along with interest at the rate of 12% per annum. Counsel for the plaintiff submit that part cause of action arose within the jurisdiction of this court and part cause of action arose within jurisdiction of the court. Accordingly, prays for leave under clause 12 of the latest patent. But the learned counsel for the plaintiff peruse the materials, produce the print and the documents available on record. This court finds that part further action arose within the jurisdiction of this court and part further action outside the jurisdiction of the court. Accordingly, leave under clause 12 of the letter patent is granted. Print is admitted subject to scrutiny by the department. Yes.
Wait, please, Your Lordship.
That one?
That one, my lord. My lord, I'll try, my lord, today, but my lord, I'll also pray that if Your Lordship is not convinced, my lord, kindly permit me to come back a week later. I'll indicate why. I have thought this over, my lord. And perhaps now I am also convinced that, my lord, at this stage of the presentation of the plaint, my lord, I can cross the threshold. Let them file a Order 7, Rule 11. I'll come back and, my lord, address Your Lordship that time. But today, my lord, very preliminary. Because that day, my lord, I was taken. In fact, I was not really prepared to, my lord, argue. So, my lord, I must confess, I was not ready. I saw, my lord, a couple of paragraphs when I tried to assist Your Lordship, but I failed in the process because I was not ready, my lord, to address on all the points. Today, my lord, I've cross-checked all the documents. My lord, first, my lord, the narrative of the matter. Otherwise, my lord, I can't really convince Your Lordship on the point of law which I'll urge. My lord, once a demurrer is filed, because, my lord, today we are at a stage where, my lord, a proceeding has happened. An ejectment suit was filed. So first, my lord, may I take Your Lordship through what the suit was. The plaint, kindly take up, my lord, the plaint is at page 49. And I'll indicate very quickly, my lord, not take more than 5-10 minutes to indicate. Your Lordship will find the plaint which starts from page 49. The second paragraph, my lord, states by virtue of a registered deed of award. This is the arbitration award which they are referring to. Of 21/5/2002, one Baloy Chandra Das, Nuni Gopal Das became absolute owner of the premises, so and so. Entire second, third floor of the building, along with common right of way. Schedule B of the said deed, third floor occupied by Anand Kumar Rungta. That's my lord, the present plaintiff. Of the petition under Balai Chandra Das as monthly tenant, said name was wrongly typed as Hemlata Rungta. Similarly, Nuni Gopal Das, the other party, became absolute owner in respect of the front portion and ground floor of the entire first floor, fourth floor of the common right, etc. And Hemlata Rungta was a tenant under said Nuni Gopal Das, monthly payment of 500. Paragraph 3. This is very important, my lord. That the said mistake was subsequently rectified by the deed of declaration dated 24/11/2004, which was registered before the Registrar of Assurance, Kolkata. I pause here for a moment. But this is the deed of declaration, which, my lord, we are now seeking a declaration. This is null and void, because by this deed of declaration, their averment is, there's no other averment here, my lord, in the plaint. The only reason I showed this is paragraph 3 is the only paragraph in the plaint of that ejectment suit which refers to this deed of declaration, nothing else. Not after this, the next page is the prayer, simpliciter ejectment. On the ground of necessary requirements, section 6. Thereafter, kindly take up our petition at page 52. In that proceeding, the ejectment proceeding. So, ejectment proceeding is essentially on the basis of an award. And not even the award, it is on the basis of necessary requirement. So, section 6. Now, my lord, kindly see our petition at page 52, which I had read out, my lord, on the last day. Kindly permit me to refer to the typed portion at page 53, capital A. 3 paragraphs, my lord, I'll refer to. 2, 3, and the second part of the third paragraph. My lord, paragraph 2, that it has been mentioned in the ejectment suit that there has been some mistake about the name of the tenant in the partition deed, which was rectified in the deed of declaration dated 29/11/2004. Duly registered, that before starting of evidence of the petitioner under 7.2, if the alleged deed of declaration is not inspected, yes, kindly mark this. Yes. Our stand is, if it is not inspected, it is not possible for the defendant to prepare the affidavit in brief and to proceed with the hearing. Your Honor would be pleased to direct the petitioner to file the alleged deed of rectification dated 29/11 in the court for inspection. So we have stated there, my lord, that this is required for inspection to enable the defendant to proceed with the hearing. Now, my lord, kindly take up the order, which is at page 56, capital A. page 56, capital A.
Yes.
Filing of the instant petition, defendant has prayed for directing the plaintiff to file alleged deed of rectification dated this in courtroom for inspection to enable the defendant to proceed with 7-2. Defendant clarified that the necessity for inspection of the aforesaid, the next page is 57, capital A, my lord. 57, capital A.
Yes.
Deed arose because the main dispute is with regard to 7-2. Is the location of the tenancy. Defendant further urged that in the plaint it has been stated some mistake about the names of the tenant in the partition deed. Accordingly, the partition deed was rectified on the deed of declaration dated 29/11/2004. Plaintiff filed written statement, written objection against the instant petition, dismissed the contention of the defendant, alleging that the petition had been filed only with the intention of derailing the fair proceedings of the suit. I have perused the plaint. As per the plaint of the plaintiff, owner of the entire second, third floor and defendant in respect of the entire third floor of the same, defendant has not filed a written statement against the plaint till date. In application, defendant will kindly take up 59, capital A, where the finding is very important in the second and third paragraph. Considering all these facts, it's 59, capital A, my lord.
Yes. Yes.
Considering all these facts and circumstances and the opinion of the defendant, cases shown irregularities in file of the defendant, ejectment of right, he has challenged the status of the plaintiff as his landlord, and whereas plaintiff has claimed himself to be the landlord, automatically the initial onus, it must be onus, my lord, initial onus of proving the title lies upon the plaintiff. Definitely, not kindly mark this part. This is very important. Definitely the plaintiff shall produce the document in question for proving his status if deemed fit, and defendant shall be able to cross-examine. He neither producing it, but at this stage of the proceeding, with hearing of the petition for it must be section 7 of the PT Act, production of the document is not necessary. So at this stage, it is not necessary, but he will produce it. So, my lord, I am not shut down. So, my lord, today, and this was, my lord, in the year 2010, because the cross-examination commenced then. My lord, kindly see the next paragraph is also relevant. Furthermore, document has been sought to be inspected, has not been produced by the plaintiff along with the statement, shall be dealt with in the next hearing. But as of now, I do not think that it would be appropriate to pass any comment on the omission on the part of the plaintiff. So we are not rejected. It's not rejected. It's, my lord, stated that they will give this at a later stage.
Correct.
Now, my lord, kindly see the chief at page 60, capital A. 60, capital A is the chief, and the cross, I will only indicate, my lord, at page 62A, kindly see, my lord, from the bottom is the fourth last paragraph of the cross-examination at page 62, capital A.
Yes.
I am not advised whether the mistake has been rectified by a deed of declaration or not. So, my lord, it is an admission that we were not aware of, my lord, the contents of the deed of declaration. But I am making this submission consciously.
Whose evidence is this?
That this is ours. Although it is very, very interesting. I will take up page 60, capital A, my lord. The first line says, I am the constituted attorney of the defendant. Very confusing. Look, kindly see page 60, capital A. I am a constituted attorney of the defendant. I have filed the affidavit in chief. And after that, my lord, chief concluded cross-examination. So I take it, my lord, that it is our, and kindly see the first line there. I am an employee of Anand Rungta since 1988, BCom pass. So it's our witness, my lord.
Anand
Rungta is the plaintiff here.
Yeah, no, in the
Now,
suit. In the suit.
In the suit, he was the defendant. That's at page 49. Anand Rungta is the first defendant. Page 49. So it's our witness, my lord. Our witness admits that this was not given.
Attorney of the defendant, chief, further examination, chief of PI. It should be a DW1.
It should be, my lord. It should be DW1. That's why I indicated, my lord, that this is wrongly recorded. It should be DW1. 62A is an admission at page 62A that this contents were not known to us.
Whether the mistake has been rectified by the
deed of declaration or not. So we do not know.
Correct.
Now, my lord, kindly take their cross-examination. It starts from page 63, capital A. It is written as OPW1. It should be, my lord, PW1. So, my lord, that's their examination in chief, and the cross-examination starts thereafter. Kindly take up, my lord, page 65, capital A. Very important, my lord. 65, capital A, second line. 65, capital A, my lord.
Yes.
Kindly mark the second line, my lord. We have not sent the copy of the critical award and deed of declaration to the defendant.
Correct.
So we did not have a copy. So we did not know the contents of the document, my lord. We waited, my lord. Then we filed our chief at page 69 is our affidavit in chief.
Correct.
Now the judgment, my lord, which is passed, it starts from page 88. No issue has been framed with regard to the veracity of this document or even with regard to the veracity of the award. All that has been proceeded with in the, my lord, decision is with regard to reasonable requirement and nothing else. Nothing else, my lord. So the list was not pending there.
So
Now, my lord, may I?
Lordship, whether you have taken the ground in your in the written statement with regard to this paragraph 2, what is your objection with regard to paragraph 2 of the suit, paragraph 3 of the suit? What is your written statement?
My lord, the written statement is not with me. I have to, my lord, cross-check that. But today, my lord, at this stage, my lord, at the stage of the plaint presentation, my lord, my averments in the plaint are true and correct. My lord, there is a judgment which says, this is a very recent decision, my lord, of the Supreme Court in 2022, where, my lord, the point was taken in Order 7, Rule 11 with regard to limitation. And, my lord, it was contended that this should be framed as Order 14, Rule 2 as a preliminary issue. My lord, the observation of the Honorable Supreme Court in that judgment is that the starting limitation is a mixed question of law and fact. Can't be bereft of the facts.
Correct.
Now, my lord, today, if the question is with regard to the starting point of limitation, it has to be always through facts, is not law. So, my lord, I'll have a chance in my evidence, my lord, to throw light on the fact when it started. That's through the evidence. So, my lord, my submission is at this stage of the plain presentation, my lord, kindly don't throw us out. Let them file a Order 7, Rule 11 demurrer. My lord, in the course of the proceeding, my lord, we can indicate from decisions that, my lord, I'm carrying two of these decisions. Which
That's correct. That is a settled law.
My lord, my lord. I'm not, that's why, my lord, I'm carrying them. I'm not handing it over yet, my lord.
That is a settled law.
Lordship, lordship.
Limitation point, the
My
court
lord.
is slow
And the starting point, my lord, is a
court
fact.
is even Order 7, Rule 11, court is very slow to
That's
go.
what is held also, my lord.
Very
That
slow.
even it should not be held as a preliminary issue. My lord.
Preliminary issue, that is settled law.
My lord.
No, that question is not with regard to the limitation. Limitation is one of the points. Second thing,
Why not in appeal? I understood that day, my lord.
Why not in appeal?
Why not in appeal?
And
I'll try and address.
Once he has disclosed in the plaint, it is not that they have not disclosed the plaint. Subsequent to the judgment, you came to know about this document.
My lord.
They have disclosed the plaint.
They have disclosed.
Subsequently, you filed an application, but rightly or wrongly, who has advised your advocate, we don't know. It should be when the learned judge has heard that no,
They should have challenged it. They did
should
not.
have been
They did not.
challenged it.
But the language, what I indicated.
And you are not you even allowed to cross-examine the plaintiff, and you're not pressed for your application for bringing such document before the cross-examination of the plaintiff.
May I humbly submit, my lord, based on this narrative, my lord. Today, my lord, the suit was decreed in 2024 in May. My lord, the moment this was decreed, we tried to have a copy of the deed of declaration, because till then, my lord, the suit, my lord, the cause of action in the suit is not based on the award. The cause of action is not based on the deed of declaration. It's only intimated. My lord, the knowledge is whether it's a knowledge of the document or knowledge of the contents of a document. My lord, there are 3 decisions which I'm carrying, which say it is the contents of the document. The moment I come to know about the contents of the document, it is then that my right commences to, my lord, challenge it. And that is the, my lord, initiation of the cause of action. That is, my lord. So today, my lord, I have an option in the suit, in the present suit. Also, I understood, my lord, what was troubling your lordship is, my lord, because the appeal is pending before Shialda court. My lord, that appeal is on a different premise. The appeal is on a premise that the ejectment suit was decreed on the basis of reasonable requirement. Award was not considered. Deed of declaration was not considered. Today, even if I bring on this document on record before the Shialda court, my lord, in an Order 41 Rule 27 petition, there will be no prayer in the appeal, my lord, because the appeal is the continuation of the list of the suit. Suit is not mine. So in the appeal, I will not have a separate prayer to have a declaration on this document.
That's why I told you. That's why. See,
so, my lord, it's a fresh proceeding before this honorable.
Had the knowledge of even.
No, I did not. My contention is this, my lord.
You had the not with regard to the contents of the
I'm very grateful.
declaration, but you had the knowledge with regard to the document.
The document, yes.
Once you received the summons from the court,
my lord,
from the learned court, and subsequently you have filed an application for production of the document, but the court has not passed any order.
The reason is this, my lord. Subject to correction by your lordship. My lord, the reason is, in the final hearing stage, we were awaiting, my lord, whether this will be argued. Because, my lord, it is pleaded in the plaint. But, my lord, I'll also show from the documents.
Suppose
My lord.
today you have been granted leave now.
Lordship.
Correct.
My lord.
What is your prayer in the suit?
Declaration.
Declaration of?
My lord, the declaration that this document is
declaration to be declared as a null and void.
Null and void.
Correct.
My lord.
If that to be declared as a null and void and the appeal is been
Appeal is,
appeal
I'm
is
very
upheld.
grateful. I understood this would be coming from your lordship. My lord, the appeal is on a point not with regard to the award. Award.
That see.
So, my lord, this touches upon the award.
Your case is only with regard to the eviction.
Only the, no, not
Decree is
eviction.
only with regard to the eviction.
The decree is with regard to the
Decree is
eviction.
only
I'm very
with regard
grateful.
to the eviction
Very
on
grateful.
the ground of the bona fide requirement. Correct.
My lord.
On bona fide requirement. Suppose you lost the appeal.
My lord.
Correct. You lost the appeal, execution, and you will be evicted or whatever it is.
Lordship. That's a different. That's a different aspect.
Yes. What would be effect of this?
Nothing, my lord. I'll indicate. My lord, that premise, the cause of action is completely, my lord, bereft of, my lord, the award and the deed of declaration. I am waiting, my lord, for the award to be made over so that I can file a section 34, challenge the award independently. This is an independent proceeding where, my lord, this is not connected in any manner with the suit or the appeal. My lord, today the appeal is on a different premise. If I lose, I lose. I will be, my lord, forced to vacate. That's a different premise. But this, my lord, is a deed of declaration by which, my lord, the premise is very different. So, my lord, today they cannot act on the basis of this deed of declaration. Is my premise, my list, my cause of action in the present proceeding. So, my lord, at the stage of presentation, also, my lord, I have made a note of the documents which they have marked as exhibit, where, my lord, this particular document is not to be found.
Yes.
Neither of them. And that's an admission in the cross-examination that they don't know the contents of the crucial award and the deed of declaration. So, my lord, this is my argument at the stage, my lord, when they file a demurrer, my lord, that the contents would give me right. Also, I'll argue Article 14, my lord, for bona fide, my lord, because I was awaiting, my lord, the outcome of the decree, because today, my lord, my application before the trial court was not rejected per se. It was indicated that they should bring this on record if they want to toe that line. They did not. They went with reasonable requirement. And that was enough for them. They did not want to disclose this, even at the stage of the final hearing. So if I take that day as 2024 May, my lord, when it was decreed, thereafter, my lord, I have made an application. My lord, I have received this document, certified copy of this document. So, my lord, kindly permit us to argue this when the demurrer is filed. But I'm only praying for a clause 12 leave and an order to rule to leave.
Only burden of the court of
No, it won't be, my lord. I'll indicate. I'm carrying very. In fact, my lord, this was a learning process for me, my lord. I did not know.
Learning you.
Absolute learning, my lord. I did not know that there can be a difference between, my lord, different aspects of knowledge. Knowledge with, my lord, the contents, knowledge with the intention, knowledge. So, my lord, that kindly permit me to argue when they file a demurrer. My lord, kindly allow us to, my lord, the plain to be presented and allowed, my lord, so that I'm only praying for a clause 12 leave. There's no, my lord, impediment to that leave and the order to rule to leave.
Suffering for the plaintiff. The plaintiff has filed the present suit, praying for decree declaring the alleged deed of declaration dated 24th November 2004 to modify the purported award, arbitral award dated 21st of May 2002 is bad in law, and further decree. Full stop. Counsel for the plaintiff prays for leave under clause 12 of the latest patent 1865, as well as under order 2 rule 2 of the Code of Civil Procedure. Consider the submission made by the counsel for the plaintiff, peruse the materials on record. Full stop. Counsel for the plaintiff submit that and record. It is found that the part cause of action arose within the jurisdiction of this court and part cause of action arose within the outside of jurisdiction of the court. Accordingly, leave under clause 12 of the latest patent is allowed, is granted. Leave under clause 12 of the latest patent as well as order 2 rule 2 of the CPC is granted. Plaintiff is admitted subject to scrutiny by the department.
I'm very deeply obliged, my lord. Very deeply obliged. I will await, my lord, the demurrer so that I can argue this point. I'm
Not
very
satisfied.
My lord, I'm very deeply obliged.
If the determination will there, then it will be a very interesting point in the order 7 ruling.
It will be, my lord. It will be. I'm very deeply obliged.
Yes, next. क्या है? 11:30 प्रेजेंटेशन है, दे दो जल्दी दो।
Lordship, I appear for the plaintiff. Lordship, I am seeking leave under clause 12 and order 2, rule 2. There are 2 more leaves that have been paid, Lordship. I feel that that would not be
Why order
required.
2, rule 2 and 4 also?
Lordship, that I said, Lordship, order 2, rule 4 and clause 14 that has been written, Lordship, with your kind indulgence, I'll not be pressing for that. We won't be requiring it, Lordship. I've gone through entirety. I'm requiring a clause 12 because 1 defendant is within jurisdiction and 2 are outside jurisdiction. I'm requiring order 2, rule 2, Lordship, because I've pleaded fraud. And paragraph 17, I've said I do not know the exact extent of the fraud. May I just tell you, Lordship,
When
what
the cause of action arose?
Lordship, cause of action arose in 2024.
When the last payment was made?
Lordship, may I just tell you, Lordship, about the payment, Lordship. May I just tell you, Lordship, respondent number 1 is my employee who was an accountant. The defendant number 2 is a chartered accountant, and defendant number 3 is the chartered accountancy firm. So, Lordship, what happened is the firm was given the responsibility of filing all my taxes, and it was on the basis of recommendations of that employee who was working with me for 30 years. This employee retired, my lord. And thereafter, the new employee came in and did an audit. And I realized that over the period of 6 years, I have actually ended up paying.
When the audit was done?
Lordship, that was done in September 2024, my lords, when I got my new person. And I realized that over the period of years.
From which years?
Lordship, we have been paying from 2019, from financial year 2019-20 to financial year 2023-24. Last payment was made, my lords, to these, Lordship, is 28th of March 2024.
So how you can siphon off this amount? How?
No, Lordship, what has happened is what they represented to us, my lords, is that the amount that has to be paid to the tax, let that be given to the personal account of defendant number 2, and she will pay on my behalf. Lordship, I have transferred money. I've got the.
You wanted to save your tax.
Lordship, Lordship, what I was paying to my account to the chartered accountancy firm. And the accountancy firm was paying the money. Lordship, that had to be shown by them. Lordship, what I realized is over a period of years, they have charged more than 72 lakhs from me. And when
You have saved the tax, now you're to
my lords, the tax has not been saved, the tax has been paid, my lords.
Okay.
Lordship, this is the transaction, Lordship.
Only clause 12.
Clause 12 and order to rule 2, my lords.
Why order to rule 2?
Lordship, order to rule 2, my lords, will kindly see because I have pleaded the fraud. I have pleaded that para 17, I am not aware of the entire fraud that they have
filed the present suit for recovery of money of amount of rupees 27,83,495 and further amount of rupees 49,79,095 along with interest at the rate of 18% per annum. Counsel for the plaintiff prays for leave under clause 12 of the latest patent on the ground that part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of the court. The plaintiff has also prayed for leave under rule 2 of order 2 rule 2 of the CPC and submits that there is every chance that further damage can be assessed and the plaintiff can pray for further damage. Considering submission made by the counsel for the plaintiff, leave under clause 12 of the latest patent as well as order to rule 2 is granted. Counsel for the plaintiff has not pressed for leave under order 2 rule 4 of the Code of Civil Procedure. Accordingly, plaintiff is admitted subject to scrutiny.
Order to rule 4 and clause 14, both I am not pressing.
No, that's why.
Lordship, grateful.
Order to
rule 4 and clause 14 I am not pressing.
Order to rule 4 and
clause
14
I am not pressing.
Is not pressing.
I am so grateful, man.
Yes, call the fixed matter.
730, item number 18 of the non-commercial.
But now a complex.
Yes. Well, I am appearing on behalf of the plaintiff in this matter, Miller.
Yes.
This is my suit for recovery of money lent and advanced, where Miller, the plaintiff says that an amount of rupees 30 crore,
GA1,
33 crore, yes,
GA1,
GA1. GA1, Miller, is my application for judgment upon admission, also seeking injunction, security and attachment before judgment. But right now I am, Miller, placing before your lordship the reasons why the plaintiff is entitled to a summary decree through judgment upon admission. Now, this is, according to the plaintiff, a simpliciter suit for recovery of rupees 3 crore, which was lent and advanced to the plaintiff, to the defendant by the plaintiff on 12th of March and 13th of March in 2018. Your Lordship, Milord, we had shown, but since, Milord, we have been arguing this matter at a long stretch, may I, Milord, kindly request your Lordship to take the general application once, Milord, one, if that is with your Lordship, Milord, kindly takes up, Milord, my bank statement, which I have disclosed. It is, Milord, at page 31 and 32.
Yes.
Your Lordship has taken a note, Milord, page 32. Milord, the entries from the top.
Yes.
Debit entries till the entries, Milord, just before opening balance are the, Milord, amounts which were transferred on 12th of March 2018.
12th of March and 13th of March.
And below the next page are the entries, page 33.
13th March.
RTGS from Pranava City Complex, 1 crore. And again, Milord, 6th entries from the bottom, another rupees 1 crore, Milord, is the amount which was transferred. So, Milord, on these two dates, that is 12th of March and 13th of March, these are very vital dates, Milord, because the defense taken is a circuitous transaction, Milord. These two dates are very important, and here two companies, Milord, are going on with the transactions. Companies, Milord, are all juristic entities. So the plaintiff company is transferring an aggregate amount of 3 crore to the defendant company. There is no private individuals involved as far as, Milord, these two documents are concerned. Even if I am, Milord, put to trial, I can easily prove these bank statements. For this, a trial may not be necessary, because this particular document, and in that sense, none of the documents which we have disclosed with our plaint has been challenged. The veracity, the contents, and the truth of contents of all the documents which has been disclosed with the plaint have been admitted by the defendant. They also admit that it was a loan which was given. They admit 9% interest was the interest. They also admit confirmation of accounts. They too admit that tax has been deducted at source and deposited. But according to the defendant, these were all paper transactions. Now, Milord, if your Lordship kindly takes up one paragraph from the plaint to show that we have made out a case for loan. It's admitted. I will also show that. Kindly, Milord, takes page 19. It's a part of the plaint.
Page
Which
19?
begins, yes, Milord. The plaint begins from page 16.
Yes.
I'm drawing your Lordship's kind attention to page 19, only to place, Milord, paragraphs 3 and 4 of the plaint.
That you already argued.
Yes.
What is the reply to the, because they have taken the stand with regard to the transaction to the other party?
I am, Milord, I need
That
to
is the
show your
only ground.
Lordship certain dates. How these dates, Milord, coincide with the defense set up now. That's why, Milord, I am trying to show your Lordship a few documents. And also, Milord, because Mr. Dutt is stuck in the next quote in 37. Milord kindly takes up, Milord, the next page, if I may draw your Lordship's kind attention, page 37 once, Milord.
Yes.
This is, Milord, the balance, the confirmation of accounts. Here, Milord, Pranava City Complex is the plaintiff and Gyan traders. They say, please confirm that the following transactions were held with you during the accounting period 1/4/2017 to 31/3/2018. This is a very important statement because as on 31st of March 2018, the defendant is admitting that rupees 3 crore was received on account of loan. And why I say on account of loan is because your Lordship will find, Milord, entries with respect to TDS at page 37. Kindly marks the figure 14550, 14,550. This is, Milord, the interest component. TDS on the interest component. Milord kindly takes up the very next page, page 38. This is, Milord, the document form 26AS, which shows that tax was deducted at source and deposited. This is very important because
Yes,
your lordship
sir.
will find the
Mr.
figure
Mr.
matches.
Banerjee, this already
No, the
pointed out
date.
during at the
Yes, the date is important.
Correct.
Because I have to, Milord,
I
show
have
your
taken
lordship
note
how.
of it when you argued the matter. Mr. Dutt has argued the matter. I have taken all note of it.
Milord just appreciates the date, Milord. Date of booking, Milord. Kindly appreciates the date. Date of transaction is, Milord, 31st March. Why I say date? Because they are showing that on this very particular date, there has been, Milord, money gone out. So it has to, Milord, these are companies involved over here. No private individuals are involved here. Milord, kindly see 31st March 2018 is the date of transaction. Gyan traders, your lordship must have marked it. Also, Milord, kindly see date of booking. That is 29th May 2018. So, Milord, as on 29th May 2018, the defendant accepts that this is a loan only between two juristic entities, the companies. So, Milord, their defense is that by 22nd of March 2018, and here, Milord, is the importance and significance of the dates. By 22nd March 2018, money had been routed back to the group of companies where the plaintiff company is a part. This is the defense. That's why I'm, Milord, showing this document only to apprise the dates. I'm aware your lordship has taken copious notes of all our arguments. So, Milord, this date is also very important. 29th May 2018, which is post 22nd March 2018.
Yes.
So, on this date, they accept that this is a loan. Why? This, Milord, provision has been shown to your lordship on numerous occasions. 194A, that is interest and interest on securities.
Correct.
Interest and interest on securities, Milord, is only with respect to loans. And in this transaction, it is particularly with respect to loans. Now, they don't stop on 29th May 2018 with their own admission that this is a loan and they have to repay with 9% interest. This is the exact 9% interest. Now, Milord kindly takes up page 41, that is 194A is given, interest other than interest on securities. This has been shown to your lordship. Milord, please takes Milord page 43. This is also a very important date. Here, Milord, this is also a certificate under section 20, form 26AS. And the transaction date your lordship will find 31st March 2019. And the booking date is 31st May 2019. So as on 31st May 2019, this is, Milord, continuing to be a loan transaction. Of course, this is a document, Milord, where the plaintiff is involved, but the defendant has not, Milord, protested to this document in any manner, other than saying that these are all paper transactions. But there is no effort taken by the defendant to approach the correct authority for rectification of these papers. So, Milord, what happens if this goes to trial? These documents, Milord, are unimpeachable at this particular stage. According to us, Milord, there is no requirement of this document to be further proved, and there is no scope of disproving it. So there may not be any necessity for us to specially prove the bank statement which I showed, the confirmation of account. Milord, I am led by Milord. You take the cases. Sorry, Milord, I got
Yes, continue.
No, please go there. Milord,
Milord, I am in reply to their application, Milord. Milord, my application was simpliciter an application for judgment on admission. The admission, Milord, we tried to find the basis of this admission on 3 documents. One was a balance confirmation, and there are 2 TDS certificates. Now, that apart, Milord, we had given them a notice of demand to which there is no reply. Now, in the affidavit in opposition, Milord, my learned friends' clients have tried to make out a case which goes beyond that. My lord, he does not deny the execution or contents of any of the three documents on the basis of which I have founded my claim on admission. He says, and categorically says, even in his pleadings, faced with a challenge that you have admitted a loan, that yes, I had received the money. He goes on to say that yes, I have signed the balance confirmation. He says, yes, I have signed the TDS certificates. Now, my lord, the authorities which my learned friends have cited, my lord, and also other authorities, they say that admission has to be clear, unambiguous, and positive. I can understand that prior to the litigants coming to court or when the cause of action arises, there are various facts which surround the execution of a document or signing of a balance confirmation. But once, my lord, he is confronted that, look, there is an admission and there is a document which I'm going to exercise against your rights to protect, my lord, then, my lord, comes the question of pleadings. In the pleadings also here, my lord, your lordship will find that there is a corroboration of what I have stated in my application and plain to be correct. Now, my lord, if I may ask myself this question, that based on the test which, my lord, Order 12, Rule 6 lays down, what more remains? Your lordship is looking at a confirmation which the defendant says is yes. Your lordship is looking at 2 TDS certificates which corresponds to the loan amount, and my learned friend client says, yes, I have signed this. So on the basis of these three facts, my lord, in my respectful submission, my lord, it is both clear, unambiguous, and positive. Positive meaning, my lord, my learned friend, even after being confronted, says that yes, I have done it. So therefore, he stands by the admission. Now, apropos that, my lord, he is tried to make out a story. I don't say it's a story. Let's proceed on the basis what he says is correct. He wants to say in certain terms that, look, yes, I have signed these, but these were actually documents to camouflage a transaction which had actually happened. Accept this to be correct. I'm inviting the court to accept this to be correct. And the only advantage that I have is that he has gone whole hog. He has been given all the opportunities by filing an opposition, by filing a supplementary, to come out with his best defense. That this is the evidence that I am in possession of, which would nullify or put a doubt on the admission that I have made. Having said that, I don't deny. Now, if your lordship finds that even to the best test put, if this defense goes to trial, there is no possibility of this defense succeeding, then, my lord, as I say, my lord, the positive assertion, even in the pleadings, my lord, will. Now, on this premise, my lord, I may just trouble your lordship with the defense that he has taken, because he had the occasion, my lord, to file an affidavit in opposition and, my lord, a supplementary affidavit. So, my lord, I don't think it is anybody's case that proper opportunity has not been given to defend. Now, my lord, kindly take a look at his affidavit, which we initially filed, being an affidavit of Sanjeev Bubna, affirmed
July 19.
I'm sorry, my lord.
19 July.
My lord, in my it's unspecified, but it would be 19 July. Yes.
Yes.
My lord, in paragraph 3, my lord, permit me to go very slowly because I will have to now show to your lordship, my lord, that this doesn't stand. The respondent is a registered non-banking financial company and permitted by Reserve Bank of India to carry out specified financial activities. copy of the certificate of registration, no problem. Then, the central figure in the transaction. Will kindly bear in mind that there is one plaintiff, Pranava City Complex. It's a company. And Gyan Traders Limited is another company. Nobody is disputing this. The central figure in the transaction mentioned in the plaint has been Mr. Raju Patni. So he drops a name that there is a gentleman called Raju Patni who was carrying on business as stockbroker and also other businesses through several companies promoted and controlled by him, including Sagittarian Credit Private Limited. Pause here for a moment, Millard. What has the plaintiff got to do with this paragraph? Nothing. So far as the plaintiff is concerned, he doesn't allege here in this paragraph that the plaintiff has anything to do with it. He says there is a gentleman called Mr. Patni.
Yes.
He owns and manages, he has companies and he has controlling interest in a company called Sagittarian. Very good. Nothing to do with the plaintiff. The respondent company, as an NBFC, had several transactions with Mr. Patni. So Patni is connected to the defendant, controlled by him in past courts whereof Raju Patni had secured my confidence. So Raju Patni is a stockbroker of the defendant.
Between them.
Between them. In March 2018, Raju Patni met me, that is the defendant, with a proposal to assist transfer of funds by one Pranava City Complex Private Limited, the petitioner company, stated to be controlled by Mr. K.R. Pradeep, to Sagittarian. So what he says, that Patni came and said to me that there is a company who wants to pay money to me, to Patni, but I want to use you in the meantime to transfer the funds. Funds has to go to Sagittarian according to him. Very well. Respondent company as a conduit. I was told that Mr. Pradeep was a promoter of well-known Kare Group and various companies under his fold and also promoter and director of Lucky Villas. Nothing to do with our plaint. Mr. Patni represented that this transfer of funds will be shown as loan on paper and the amount of the funds to be provided by the petitioner company will carry interest at the rate of 9% per annum. Stop here for a moment. What Mr. Patni represented is that a loan would be given by the plaintiff to you.
Correct.
Correct. That is a loan. Then, funds provided by the petitioner company will carry 9% per annum, whereas the funds would be passed on by the respondent company to Sagittarian ostensibly as a loan and would carry interest at 11% per annum.
They will take further 2%.
So the transaction has two parts. He says that defendant had a contract with a third party that a loan will come into your account. I am saying that loan was given. What the defendant will do with a third party is not in the plaintiff's concern. So what he is trying to do, he is saying that the loan will come from 9% to my account, and thereafter, on the basis of my agreement, the defendant's agreement with we will transfer it amongst ourselves.
Yes, he is paying you to 9% and he
So
will take
therefore,
11%.
the plaintiff is paying, according to him, the third party, who is the stockbroker of the defendant, has said that some money will come to your account and you pass it on to me. Now, this passing on from the defendant to Sagittarian has nothing to do. But if he is a company, the moment he receives the money in his accounts, it will be shown as a loan taken from the plaintiff. That he doesn't dispute and cannot dispute thereafter, Miller. Whereas the said funds would be passed on by the respondent company to Sagittarian ostensibly as a loan and would carry interest at the rate of 11% per annum, thereby giving the respondent company a margin of 2% profit of the amount of fund handled. So, for purpose of showing me that I have taken a loan, I will charge you an interest of 2%. So I have an interest in that. It's not that I'm just a conduit. So I am charging you for the purpose of taxing my books to the extent of that.
Correct. He's taking 2%.
So therefore, he's not doing it for
as agent,
free.
whatever it may be.
So whatever it may be, if he is an agent, he's an agent of some third party, not of the plaintiff.
Correct.
I'm only trying to show the connection with the plaintiff is not being established. So, and would carry interest at per annum so and so. Then, this is very important. Mr. Raju Patni represented that the project would be completed in the financial 2021, during which, this is very important, Sagittarian would transfer the amount of funds handled by the respondent company with interest at the rate of 11% per annum, and the respondent company, upon receipt of the said amount, will pass on the amount after retaining 2% of the margin of profit back to the petitioner company, which would be shown on record as repayment of loan. So it's a U transaction. Plaintiff, defendant, Sagittarian, Sagittarian, defendant, plaintiff. Now, Mr. Patni assured, so Millard, what I was trying to say is that if for the defense is that I have repaid the money. Now, subject to correction, Millard, my learned friend's pleadings, both in this affidavit as well in the supplementary affidavit, does not show or establish that he has repaid the money back to the plaintiff. He doesn't even say so. His case, as I proceed, I'll show, he says that I received the money as a loan. I passed it on 21st of March to Sagittarian. Correct. The story stops there. The reverse story is not being established. If the reverse is not established, then Millard, in his books, the loan remains unpaid. In my books, the loan is outstanding. The admission of the loan is in the pleadings. So what more, Millard, if I may ask myself this question? Let me proceed, Millard. Let me proceed. So the transaction was a U transaction. Mr. Patni assured me that the respondent company would be running no risk. Why? Because no amount would be payable to the petitioner, kindly mark, Millard, until and unless funds were received from Sagittarian. Yes. So till such time Sagittarian gives back the money to the respondent, you don't have to pay anything, so you don't have a risk. Correct. On behalf of the petitioner company, Mr. K.R. Pradeep confirmed that the petitioner company would not demand repayment till the respondent company received the funds. Kindly mark this word. This is the first allegation made against the plaintiff, that a director has said that don't worry, I will not make any demand from you. The reason why I say so, my lord, before filing the suit, we had served upon them a notice of demand. And that notice, if this has been the actual transaction, then the first and foremost reaction would be to answer to that demand saying that no, this demand is incorrect because your Mr. Pradeep had said that I won't be responsible and nothing has happened. There is no reply to that notice.
Okay.
So June 2023.
At page 53 of the page 49 is the petition, is the notice of demand.
Page
49 is the notice of demand of the petition. And page 53 is the track report of receipt of the petition. So, Millard, anybody receiving a notice which is preceded by such an understanding allegedly would instantly write back saying that no, I have not been benefited. This loan was given. This was the understanding. There is nothing on record. And they don't even claim now that after receiving the demand, we have said this. No. I asked Mr. Patni as to why the money would not be paid directly to his company, Sagittarian, by the other company. Mr. Patni explained that the amount received by his company, Sagittarian, from Pranova group of companies controlled by Pradeep was in excess of 24 crores, and the banker of Pranova group was objecting to such overexposure and insisting on reduction thereof. So, my lord, who is overexposed? The person who is giving the loan is overexposed.
You are having the excess amount.
So, if I am having that overexposed amount, then where will I give it?
Yes.
Overexposure, my lord, as I understand, is that my limits, I have crossed my limits with the bank. So, if I have crossed my limits with the bank, how can I be party to a transaction where I'm giving more money?
Yes.
Then, and the banker or the borrower has objects then. In the circumstances, to reduce the exposure of such and such as companies, the petitioner group, two Sagittarian, Mr. Raju Patni and Pradeep, devised a scheme to route money through the companies known as Patni to act as conduit and recycling funds. Well, pausing here for a moment. If I am to recycle funds, meaning thereby what? That I am paying off to reduce, and somebody is receiving the money and retaining it in the same. Now, my lord, the evidence in the first paragraph of the what should I say, my lord, in this previous paragraph and the subsequent paragraph are contradictory to each other. Why? Because the scheme that was to get over the exposure of Pranagov to Sagittarian and reduce subsumer resign, Mr. Patni represented that the amount would be received from the respondent company. Kindly, my lord, mark, my lord, this is another. Mr. Patni represented that the amount that would be received from the respondent company would be immediately paid by Sagittarian to
Pranava Electronics.
Pranava Electronics Private Limited. It's not the plaintiff.
Correct.
So, therefore, the first part of the paragraph says plaintiff, defendant, Sagittarian, Sagittarian, defendant, plaintiff. Now he is trying to say that the scheme was plaintiff, defendant, Sagittarian, another company. Nothing to do with the plaintiff. Mr. Patni and Pradeep assured me that the respondent company would be acting in and they would have no risk or harassment. The respondent company would not be required to pay any interest, nor would have any obligation, so and so. Relying on the aforesaid representation and assurance confirmed by Mr. Pradeep on behalf of the petitioner company, I, on behalf of the respondent company, agreed to the aforesaid proposal. Thus, a tripartite agreement was entered into between the petitioner company, represented by its director and the person in control, Pradeep, Sagittarian, represented by its director and person in control, Mr. Raju Pandey, and the respondent number 3. Very good. What was the agreement? Mr. Pradeep, through his company, would transfer funds to companies controlled by Raju through respondent company as conduit, not referring to any plaintiff, defendant, anything.
Yes.
Respondent company would get a commission of funds so handled, which would be paid in form of difference between the amount shown as interest to be paid by the company of Mr. Raju Pandey to the respondent and the amount ostensibly shown as interest as lower rate payable by the respondent to the company of Prayer Pradeep. So, when he says that if you are getting 11% from Sagittarian, you paid back with 9%, you retain 2%.
2%.
Transactions will be closed by 31st March 2021 when Raju Patni's company would transfer back the fund to the respondent company with 11% of the fund transferred by the respondent, and the respondent would transfer the said fund to the company of K.R. Pradeep with additional amount of 9% of the funds so handled, thus receiving commission of 2% handled. Well, if I may ask myself this question, if you have been party to such a transaction, let's take it. This transaction is not illegal. Why? Because all transfers are made through banks. If you have been a party to a transaction and if you have retained 2% as a consideration for being party to the transaction, then why will you not be responsible? You are taking a consideration for it.
Correct.
So the respondent, then D, the respondent would refund the fund to the company of Pradeep only upon receiving back the from the company of Mr. Patni the funds of company transferred. So respondent will not be liable to categorical statements throughout. I am not liable to pay you till such time Sagittarian pays me, and I will not be liable to pay you anything. Respondent would refund the fund to the company of Mr. Pradeep only upon receiving back from the company of Mr. Raju Patni the funds of Pradeep transferred to the company through its respondent.
Correct.
and all transfer of funds would be made through banking channel. So, my lord, the agreement pleaded, if taken to be correct, only goes to show that there was a U transaction, plaintiff, defendant, a third party, who the defendant claims is his stockbroker. And all these paragraphs which I have just now read, my lord, this subparagraph 4 and subparagraph thereafter, does not anyway say that the plaintiff also affirmed it. All it says is that this understanding was between me and my stockbroker. It doesn't. So if this was the understanding, and if this is what does it show? The aforesaid agreement will be corroborated and evidenced by the conduct of the parties. This is, my lord, where I say your lordship will test whether the requirements of 12.6 are being reaffirmed over here. The aforesaid agreement will be corroborated and evidenced by the conduct of the parties.
Yeah.
The funds of 3 crore received from the petitioner company. There is one admission here in pleadings.
Yes.
Was transferred to the respondent company to Sagittarian on 22nd March 2008. And as informed by Patni, which I believe to be true, and had transferred the sum of rupees 3 crores by Sagittarian to Pranova Electronics Limited, a sister concern of the company, on 12th and 13th of March 2008. So, he has received the money, he has passed on to Sagittarian. The agreement was Sagittarian will pay it back to the respondent and vice versa. This has not happened over here. 1. No TDS certificate was ever issued to the petitioner company. No interest was paid to the petitioner, nor did the petitioner company demand it. Only, another admission, only one balance confirmation was issued for 1 year. That is my second evidence, which I had brought before the court for the purpose of my admission.
Yes.
And TDS deposit made for 2 years, only giving the color of a loan transaction. TDS is the third document which I have relied.
Yes.
And my case in the petition is that it was a loan transaction.
Yes.
So, my lord, this is, if I may say so, with respect, a positive assertion by the defendant that the admission on which the plaintiff is seeking a decree is correct.
Okay.
Now, kindly see paragraph 6. In pursuance of and the basis of the aforesaid tripartite agreement, the petitioner company made online transfer of 2 crores on 12th March and 1 crore on 13th March to the respondent. Admission. On 22nd March, the respondent company transferred 3.15 crore to the Sagittarian. Not my concern, it's between him and a third party, not the plaintiff's concern. Out of the sum of 3.15 crore, this is very important, my lord, out of the sum of rupees 3.15 crore, he received 3 crore, 15 lakhs was paid to Sagittarian towards payment of a previous loan. So this shows and confirms that there is already an existing juror relationship between the defendant and that third party. They are already carrying on business.
Yes.
So there is a juror relationship between them.
Yes.
I was informed by Mr. Raju that on 12th and 13th of March, Sagittarian transferred an aggregate amount of 3 crores to Pranova Electronics Private Limited.
Yes.
Not the plaintiff. All the aforesaid transfers of the amount were shown on paper as loan transactions, but were actually circular. So, my lord, the amount transferred by the petitioner as shown as loan carry interest at the rate of 9% per annum, and the amount transferred by the respondent to Sagittarian as loan carry interest at the rate of 11% per annum. So this has happened. So if the reverse has not happened, he by his own admission says that the loan in the books of the plaintiff remain outstanding. This is, my lord, the outcome of this. I received, I paid it to Sagittarian. The agreement was that it should come back through me to the plaintiff. That has not happened. So in his books, there is a loan. In my books, the loan is outstanding. Then, It was later informed by Mr. Patni that the aforesaid process exposure of Pronova Electronics Private Limited to Sagittarian on paper reduced to approximately half by the transaction of the funds recycled. So, my lord, what is happening is my learned friend is not being able to, in spite of my lord getting a chance to, is not being able to nail the plaintiff as to this transaction which he is trying to show as a defense. He is saying many things has happened. He is saying money has come, but he is not being able to show, which he has been trying to argue, that I have repaid the plaintiff. Therefore, the plaintiff is not entitled to a decree.
Okay.
This he is not being able to show. Now, my lord, kindly come. Then he, my lord, refers to certain my lord, police complaints that have been lodged, where he says that Patni was there, I was there. All I could understand, my lord, that though he is very heavily relying on Patni's evidence, but from the subsequent paragraphs it applies that Patni can't be his witness. So that's the reason, my lord, your lordship will come back to your lordship, that in some stage of the suit, they made an application before filing a written statement that Patni should be added as a party to the suit, which was rejected. Appeal court also read. Because my stance was very simple, that I am the plaintiff, I am alleging loan, the burden is on me, I am to discharge. Now, if I feel that by suing you, I can discharge my burden of loan, I don't need to bring in anybody. I am the dominus litis. Now, therefore, you don't have the right to say, until and unless you prove the loan, that look, third party rights are involved. So, that way, my lord, so far as the rest, my lord, are not really relevant and not necessary. Now, my lord, kindly come to page 114. No, what? Of the opposition. Sorry, sir. This is being relied upon, which shows, my lord, the third entry was shown is that 3 crore 15 lakhs has been transferred. Now, my lord, test this document vis-a-vis the story that has been, or whatever defense, I don't say story, it's a defense that has been set up. This document will only show what he is saying, that funds has been transferred from the defendant's account
To
Sagittarian, along with, he can't explain 3 crore, the balance 15 lakhs he could not explain. So he says that 15 lakhs was outstanding from a previous loan transaction. So I have paid him in a total 3 crore 15 lakhs. Beyond this, his evidence doesn't go to show that he has returned the money, which is his case.
Yes.
Simultaneously, my lord, kindly now take the supplementary affidavit. Supplementary affidavit in opposition, or whatever.
Supplementary affidavit in opposition.
Yes, my lord, they got an opportunity, and your lordship was kind enough to give them an opportunity. My lord, this is an affidavit of same Mr. Bubna on 18th June 2024. OPLA.
Yes, 18 June.
My lord, all that he has to say, I say that the defendant, respondent and filed its affidavit in opposition to the application. The contents of the affidavit in opposition are true and correct. So he acknowledges that the contents are correct. One of the grounds used by the respondent in his affidavit in opposition is that the transaction of money lent and advanced between the plaintiff and the defendant, as alleged in the petition, was a sham transaction, and the real transaction was a circular deal involving the plaintiff, defendant, Pronova Electronics, Sagittarian, K.R. Pradeep, Raju Patni, and Mr. Raju Patni of Sagittarian. So he's taken now a bigger stand. But, my lord, the defendant was not the beneficiary of the sum of rupees 3 crores, very well, transferred by the plaintiff to it, but was only a conduit for routing the fund. from the bank account of Electronics Private Limited and Sagittarian, which the defendant has now been able to obtain, the circular movement of funds is clearly established. So what he is trying to now say is that although I have received the money from the plaintiff, I have given it to Sagittarian. Sagittarian has given it to a third company.
Electronics. Pranava Electronics.
Pranava Electronics.
Correct.
The plaintiff is Pranava Complex. It's like saying, my lord, I received funds from loan from Tata Finance and I give the loan to Tata Motor Vehicles or Tata Cars, whatever it is. Yes. And that would discharge the funds, loan of Tata Finance. This is the simple difference. Just
that is the case we know.
That is the. So therefore, my lord, if we are dealing with private companies which are separate legal entities, my lord, each having their own books of accounts, a fund received from Tata Funds and paid to Tata Motors will never be considered in law to be a refund made by Tata Motor to the loan received from Tata Funds. And this is exactly what he is trying to do. So even if, for argument's sake, even if he has received and paid the money to Sagittarian and Sagittarian has passed on to Pranava City, all he is supposed to do is, my lord, to sue Sagittarian and ask for return of the money.
Okay.
It's never, if A has lent money to B and B has passed on to C, you can't say that, well, if and I could have understood that his case is that B has paid to C at the instance of A. He is not saying that. He is saying that C and B, that is the defendant and third party, had entered into a transaction to do this.
But the Pranava Electronics is also a KR Pradeep.
Pranava City Electronics Private Limited is a separate company. He is trying to catch on to the directors.
Correct. That's what I'm telling.
So, my lord, it's too well settled that if liability of a director is not of the company and liability of the company. So, if I get a decree against the company, I can't execute it against the directors. So, therefore, it's a simple transaction which, my lord, is approved. The stand taken is not sustainable in law, even if it is accepted to the hilt to be correct. If it is not sustainable in law, then if I may ask myself this question, suppose, my lord, he goes on to prove that yes, KR Pradeep has received the money. So, how can you, just because I have paid it to a director, how can you hold the company liable or vice versa? So, my lord, even if this goes to trial, this question will fall for consideration, that whether a director is liable for the debts of the company or otherwise. Now, my lord, if that is proposition of law is too well settled today to be re-argued, and it is not a case of lifting of corporate veil that under the corporate.
That is not the case.
That is not the case here. So, my lord, if this is the legal defense and this is the factual defense, my lord, if I may ask myself this question, even if your lordship feels that this should go to trial, evidence is all before your lordship.
No, but on one thing is that they have filed this supplementary disclosing the document stating that the Pranava Electronics Private Limited through Pradeep it was paid. Now you are telling, you are taking the defense. Yes, KR Pradeep is the director, but it's the two entities, two companies.
Yes.
So it cannot be.
Yes.
But whether you have the KR Pradeep have filed an reply to the supplementary affidavit, this amount is the separate amount of the Pranava Electronics Private Limited against the supplementary.
Opposition to the your lordship will have my affidavit in opposition.
Anand TV.
Lord, Anand TV, yes. It would be dated 3rd July 2024.
Yes, 3rd July 2024.
Page 4, paragraph 5. Ask you. My lord, your lordship wanted to me whether I have taken this defense or not. The chart table based on the purported copies of bank statements of Pranava Electronics Limited, Sagittarian, allegedly by the respondent, does not show involvement of a circular deal or a routing of funds. Without relying upon the alleged chart on the purported copies of the bank statement, I say that Pranava Electronics Limited, Sagittarian, KR Pradeep, the plaintiff, and the defendant are separate entities. So I've taken this point. And are legally free to make independent transactions. The agreement recourse which was advanced to the plaintiff defendant was also an independent intercorporate loan received by the respondent under the terms to repay the same with 9% per annum. Not only did the respondent sign the confirmation of accounts after reconciliation admitting the facts, but has admitted paid interest at 9% and tax deducted as source. Therefore, the allegations are wholly wrong. This point has been squarely taken.
No, that's correct. You have taken my specific question, not the whether the KR Pradeep has put any document. Yes, this 1 crore, 1 crore, 1 crore, and other amounts. This 1 crore, 1 crore, 1 crore. Yeah. Yes, this amount has been received by the KR Pradeep. This is the amount which is due to the Sagittarian, this Pranava Electronics Private Limited. But where is that?
Your lordship is trying to understand that whether there is any document by virtue of which the money which is being received by Pranava Electronics Private Limited
that is
a money which is due from Sagittarian.
Sagittarian or yes, or whatever it may.
So your lordship is now trying to connect that whether this money which has been received by Pranava Electronics Private Limited is actually the money which has been paid. My lord, I got your lordship's point. Now, my lord, for the time being, let us take it as I said, my lord, the defense to be correct. I'm proceeding on the defense to be correct. The defendant is also saying so. Defendant is saying that I have paid it to Sagittarian. Sagittarian has paid it to Pranava Electronics. Therefore, the payment made to Pranava Electronics should be construed to be a payment made to the plaintiff.
Correct.
This is
the case, this simple case.
Now, to that, my thing is, at this stage, accept that to be correct. Accept that to be correct. So, my learned friend will have to go a step forward to show that, as I said, Millard, that the plaintiff is a separate company, Pranava Electronics is a separate company. I take a loan from Tata Finance Private Limited.
Yes.
Execute documents, give TDS.
Yes.
Thereafter, I have, instead of paying it to Tata Finance, paid it to Tata Motors.
Correct.
And Tata Motors accepts it.
Correct.
Now, Millard, it is for my learned friend now to show that on the instructions of Tata Finance, I have paid the money and that payment is valid discharge. Where is he running this case?
Because
so what he is saying,
no, because kindly come this their affidavit, original affidavit.
Yes.
Original affidavit, page 3, paragraph 5.
Yes.
Third line and paragraph 5.
Give me a moment. Page 3, paragraph 5. Yes.
Page 3, Roman 5.
Yes.
Now kindly page 4, first line. Sajid, and read the total paragraph.
But let us.
I asked Mr. Patni as to why the money would not be paid directly to the company Sagittarian by the other company. Full stop. Mr. Patni explained the amount received by his company Sagittarian from Pranava group of companies controlled by Mr. K.R. Pradeep was in excess of rupees 24.
Very well.
So if they have made out a case, so this is the group of company excess of 24 crores. That's why that might be. So that's why this has been transferred to the, as per the advice of the KR Pradeep, it was transferred to the Pranava Electronics.
Lord, with respect, my lord, may I read it in my, I'll try. I asked Mr. Patni, defendant is saying that I had asked Mr. Patni as to why the money would not be paid directly to his company Sagittarian by the other company, other company being the plaintiff.
Correct.
So why are you using me as a conduit?
Hmm.
So to that, the defendant, that party, the third party has explained that the amount received by Sagittarian from Pronova group of companies, so this is an existing loan controlled by Pradeep, was in excess of 24 crores. So I have already an existing 24 crore loan from the plaintiff to the to the third party.
Yes, Sagittarius.
So therefore, I cannot take any loan from him. Why? Because there has been an overexposure of the Mr. Pane, that the controlled by KR Pradeep was in excess of, and the banker of Pronova group of company was objecting to such exposure.
Yes.
So, my lord, if I may ask myself this question, how does it make any difference to what my learned friend is saying? He is saying that you have made an more than 24 crores payment to Sagittarian as loan. Bank is objecting to give a direct loan. Very well. So bank is now saying that Pranava, the plaintiff, I will object if you give any further loan to Sagittarian. So route it through you. Very well. I route it through the defendant and thereafter I pay it. It still remains a loan. It remains a loan so far as the defendant is concerned. So now the question is, so my learned friend, that's why the previous paragraph he pleads that this is a loan. The loan will go to Sagittarian and Sagittarian will give it back to me and I'll give it back to you. So I receive the money, Sagittarian receives the money and Sagittarian pays back the money through you, for which your services you will be getting 2%. And therefore the bank's objection need not be. This is all that this paragraph says. Your lordship's query was that so far as this money is concerned, this money has allegedly is being paid from Sagittarian to another group company. Electronics. So why will it not be a discharge? So to show that, my learned friend will have to plead and prove, which he has not done, that at the instance of the plaintiff, I had actually paid the money to Sagittarian, who has paid to Pranava Electronics in due of the discharge of the loan of the plaintiff. That is not the case. The case is just reverse.
Okay.
But I need some more time because some authorities have been cited.
Next day.
I thought, my lord, your lordship will be taking up 12:30. That's why I said
12:30 other matters.
But if I continue, I'll continue till 1:50. But
12:30 is other, because yesterday also I had not taken the testament.
But I think, my lord, it's time. I think Mr. Mitra will also agree. Although 15th is the date when we switch on the ACs, but I think that it's time.
No, it has to be, yes.
Very hot. Unfortunately, before the 15th of
the
February,
bar put the requisites.
the summer has come.
The census and suffering for the plaintiff, census and suffering for the defendant, counsel for the plaintiff has argued the matter in reply in connection with J1 of 2021, but due to paucity of time, hearing could not be completed. Release the matter, give the date. नहीं है. How much time will it take?
Well, I'll take another half an hour. There are 3 judgments to be cited. They have relied.
3:45. 28 February. February at 3:45.
20 February কিবার পড়ছে? Right.
এটা বলবো।
Yes.
I'm obliged.
So with my application, grant of probate.
अच्छा आज है ना, ये को बता देने भूल जाएगा. 4:15 छठी हो गया ये 30
marriage, the daughter was born, who is the heir, Ute Anita Hilda. And then thereafter another marriage with Gayatri Basu in 1992, which was dissolved in 1993.
Gayatri Basu 1992.
And which was
Also dissolved 1993 within a year.
Yes.
How it is within a year? Where it was dissolved? In India?
England, Lordship.
England. That's why India. How it is possible within 1 year? Then
And then the third marriage, Lordship, this with the petitioner.
where is that?
Lordship,
So you're not disclose any document with regard to the dissolution of the marriage.
Lordship, that my
You're not having.
petitioner is not having.
Yes. Where is that? Third marriage.
The marriage, Lordship, the deceased married your petitioner, Lordship. Lordship kindly comes to the after however the second marriage was also dissolved in
Correct.
the year 1993. Thereafter, after such dissolution, the deceased married your petitioner, but no issue was born out of the marriage. Both the second and the last marriage of the marriage of the deceased, both the parents of the deceased had expired much prior to the death of the said deceased, leaving behind the persons as stated in previous paragraph. So there are two heirs, Lordship. The
So
wife of
petitioner is the third wife.
the petitioner is the third wife.
And the second is the legal heir is the daughter of the
Of
first
first
wife.
First marriage.
First marriage.
First marriage.
And second marriage there is
There is
within
no issue.
no
The
issue.
marriage is dissolved within 1 year, Lordship.
Where is the affidavit?
Asset. Yes,
Affidavit of
Lordship.
consent.
Yes.
This one.
Fine, Lordship.
My stepmother is applying for contemplated admission. That I know. Thank you. Where is the affidavit of assets?
Lordship, affidavit of assets, it has already been filed. There is one immovable property, which is a flat
43 lakhs.
of 39 lakhs and two bank
Total 43 lakhs.
for total 43 lakhs.
So appearing for the petitioner. The petitioner has filed the present application for grant of letters of administration of the estate of the deceased. This is Arun Kumar Chatterjee, who died on, where is the death certificate?
Lordship, at page number 8.
Who died on date of death 24th November 2016.
Yes.
24th November 2016. Leaving behind the petitioner being the wife and one daughter, namely Ute Anita, A-N-I-T, Anita, Hilda, H-I-L-D-A, Hilda Chatterjee. Counsel for the petitioner submit that the deceased had initially married one Gisela, G-I-S-E-L-A, Martin, in the year 1962. And in this said wedlock, the legal heir Ute, and one daughter, namely Ute Anita Hilda Chatterjee, who was born. Full stop. The first wife and the wife Gisela Martin died on full stop. The marriage between the deceased and his first wife Gisela Martin was dissolved on 4th of August 1982. After thereafter, the testator had married to one Srimati Gayatri Basu in the year 1992, but the said marriage was also dissolved in the year 1993. Full stop. there was no issue in between the deceased and the second wife. Full stop. After thereafter, the deceased has married to the petitioner herein, and there is no issue in the padlock between the deceased and the petitioner. Full stop. The only legal heir, namely Ute Anita Hilda Chatterjee, has filed her affidavit of consent, stating that the petitioner is the stepmother, and she has no objection to grant of letters of administration with respect of the estate of the deceased to the petitioner hearing. But the learned counsel for the petitioner peruse the materials on peruse the averments, affidavit of consent of the legal heir of the deceased. This court find that the legal heir of the deceased has categorically filed an affidavit stating that she has no objection for grant of letters of administration. Accordingly, prayer A is granted. Prayer of the present application is granted. The department is directed to issue letters of administration subject to furnishing bond of ₹4 lakh with one surety on compliance of all formalities. PLA number so disposed of.
Grateful Lordship, only one indulgence. Ute Anita Hilda Chatterjee, her name in the affidavit of consent, she has also written Ute Lynch, which has subsequently she got married.
उसमें ना उल्टे इल्डा ना affidavit बोला है, उसमें देखो in the affidavit of consent, the legal heir has also stated that she, after her marriage with Mr. Peter Lynch, Lynch, she is being known as which affidavit?
Lordship, second affidavit of consent.
Known as Ute, UTE, Ute Lynch, Lynch.
Grateful
Ute Lynch. ठीक है? Next.
45. Last occasion I had sought leave to file the amendment application, my lord. Ready, my lord. Only one thing, I'll be praying for leave.
Who is for the other side? Nobody.
My lord, citation has not yet been issued.
What application?
The application for amendment of the application for grant of probate. There are certain deficiencies, my lord. Thereafter, after we have been engaged, it's been affirmed, my lord. We'll need.
Why you not filed?
My lord, we'll need the leave because master summons cannot be taken out without service. So if your lordship's officer kindly endorses it, that the leave may be granted to file it without service, my lord.
To whom you will serve? How many legal years?
Well, we can't serve because it has to go after citation.
Correct. So what
after
you want?
citation, there's only one legal.
One legal. So what you want now?
Well, now
Only leave
the
to upon
amendment application. I have an amendment application
you want
which
to
we'll file it, my lord. But my lord, the master summons which has to be taken out can be taken out only upon service.
Correct.
But since citation has not been issued yet,
Correct.
this has to be filed without service.
Correct.
The leave has to be endorsed on the master summons to that effect, my lord.
So Supreme Court the petitioner. Counsel for the petitioner submit that the application filed by the petitioner requires some amendment. Accordingly, the petitioner has taken out an amendment application along with the master summon, but no citations has been issued. Accordingly, the petitioner pays leave to file the master summon without service of notice, without service of citation. Accordingly, leave is granted to file the master summon without service of citation.
Grateful, my lord. We'll keeps it next week if so commences to your lordship.
Let the matter appear on 21st February 2025.
21st, I'm in some personal difficulty, my lord. Can we?
19th.
Yes, my lord.
19th February 2025, along with the, what is the number?
Number key.
Along
No,
with the
we'll get the
connected,
number.
along with the connected application.
Great.
Lord, I appear for the plaintiff, my lord. There was an application wherein my lord had directed the mother of the parties, my lord, to produce the document. My lord, being aggrieved from that order, my lord, we have preferred an appeal. The appeal is, my lord, due to list next week, my lord.
18th, yes.
So, my lord, may kindly adjourn.
But this order, the 16th of January, now they waited for so long, but
So and so appearing for the plaintiff.
Help, man.
It is plaintiff. So and so appearing for the defendant number 2. And you are appearing for?
For the
no,
defendant.
I am the plaintiff
He is
number
the
2.
plaintiff number 2.
Plaintiff
I
one,
am the plaintiff number 1.
Plaintiff number 1. So and so appearing for the plaintiff number 2, and so and so appearing for the defendant. Full stop. Counsel for the plaintiff number 1 submit that. Being agreed with the order dated 16th January 2025, the plaintiff number 1 has preferred an appeal and press for time. In view of the submission made by the counsel for the plaintiff number 1, the case adjourned. Let the matter appear on 28th of February.
28th, my lord. My lord, by 28th, I don't believe, my lord. Your lordship, may kindly give the
4th
further
March.
date. 4th March. Extremely grateful.
Yes.
Extremely
Next.
grateful.
Obliged.
My lord, 47, my lord, I am for the petitioner, my lord. In this case, my lord, the evidence is complete, my lord. Today is the date fixed for argument, my lord.
Yes.
My lord, may I start, my lord?
Yes.
My lord,
Where is the will?
my lord, will has been this before your lordship that has been marked exhibit A, and my lord, the signature of the
Just a minute. Where is the will?
My lord, that is before your lordship, my lord.
What is the name of the testator?
Testator, my lord,
Testator, testatrix.
Two testator and testatrix, their husband and wife.
Testator and testatrix, Patik and
Yes, my
Renuka.
lord. Another Renuka Sharma.
Patik Chandra Shaw and Renuka. Yes, where is the name of the executor?
My lord,
In the will?
My lord,
English translation.
but that is translation. English translation is there, my lord.
Yes, where is that? In which page? You're arguing the matter, you're not ready with that.
No, my lord, my lord. My lord, the executor has deposed before your lordship, my lord.
Where is the name of the executors in the will? Show me.
My lord, just a minute. In this will, I appointed two sons, Vidyut Kumar. My lord, that is a page 4. Of the English
Executors,
translation,
two,
my lord.
Vidyut Kumar Shaw and Tanay Shaw.
Tanmay Shaw, my lord.
So they are both are the petition before this court.
No, my lord. Tanmay Shaw is the petitioner and Vidyut Kumar Shaw has given consent, my lord.
Tanmay, who is the petitioner? Tanmay.
Tanmay Shaw, my lord.
Tanmay is the petitioner.
Yes, my lord.
Vidyut has given
consent, my lord.
Consent. What about the death? When
my lord,
they died?
Yes, my lord. Date is 40, my lord, 25/8/2020, and my lord, the
Renuka died 2018.
2018.
And husband?
My lord,
2020.
Chando, my lord, 40 is the husband of Renuka, my lord.
25th August 2020, husband died.
Yes, yes, my lord.
And wife died 18 prior to that.
Yes,
and
my
what
lord.
is the date of the will?
My lord, date of the will is 14/1/2011.
14/1/2011. Where is that? 14/1/2011. Where is the date of will?
Finally come to page 9. Last, my lord.
(14/9/2011). 2011.
Yes, my lord. Page 8, my lord, of the English translation. Page 8 of
How many legal layers?
My lord, 4 legal layers, my lord.
Where is that? Vidyut Kumar.
Petitioner, yes, my lord. My lord, you can also kindly come to the petition, my lord. That I
Tanmay.
stated in paragraph number 4 to 5, my lord.
Page 4.
Yes.
Page
Vidyut
4 and
Kumar. Elderson.
Yes, my lord.
He has not given consent.
He has given consent, my lord.
Vidyut Kumar given consent. And Tanmay is the petitioner.
Petitioner before.
Molly Sarkar.
My lord, she has not given consent. She lodged caveat. Subsequently filed affidavit in support of caveat, but subsequently prayed before her lordship that she will not contest the proceeding.
Where is that? Discharge of caveat, where is that?
My lord, that is before her lordship and she.
Which order?
My lord, order caveat has been discharged, my lord.
Where is that? By which order the caveat is discharged, sir?
That is the order নাই orderটা নেই মানে orderটা নেই মানে I'm just evidence of এটা কি evidence of Gautam Basu, yes. And Gautam Basu না witness PW2.
Where is the order of discharging the caveat?
No, discharging caveat মানে she appeared and submitted মানে that
অর্ডার ডেটেড তো আছে
হ্যাঁ
অর্ডার তো আছে রিফ্লেক্ট হয়েছে তো
না অর্ডারটা বলেছে
হ্যাঁ বর্ডারে বলেছে তো
এই জানুয়ারি
অর্ডারই তো বলা হয়েছে অর্ডার
Yes, 31st January, the director to bring the translated copy of the letter. Where is that? Thereafter,
No, that she has not come, my lord, before your lordship.
yes, then?
Then, my lord, matter was hard expertise.
Then Poli?
Poli has given consent, my lord.
Given consent.
Yes, my lord.
So why you examine the witness? Why you have examined the witness?
My lord, witness has been examined, my lord.
For what?
My lord, your lordship.
You are ready for the argument. You are not giving any answer to the court.
Exhibit, my lord. Exhibit A.
Why you have examined the witness?
Well, since it has been become contentious, that is why, my lord, examined the witness. Contentious, my lord. Because, my lord, see,
where is the attesting witness evidence?
Yes, my lord, that I'm telling you, lordship, my lord. I'm reading, my lord. My lord, that is what do you know? Fatik Chandra Saw and Renika Saw? Yes, I know them.
Tanmay was examined.
Tanmay was examined as PW2, my lord.
And Gautam Basu is the attesting witness.
Yes, my lord. Gautam Basu is the attesting witness. Well, see, identify the signature of the deceased.
Let me see. Let me see. Gautam Manna.
Gautam Manna, not Gautam Bush.
Yes.
Gautam Basu, my lord.
Huh?
Gautam Basu, my lord. He is the attesting witness. And my lord.
Gautam Basu, Gopal Manna.
Gopal Manna, my lord, he is one of the other attesting witness, my lord.
He has not been examined.
Yes, he has not been.
He has examined?
No. But his signature was identified by Gautam Basu, my lord. In the will.
Where is the consent?
My lord, my consent is all before your lordship, my lord. কোনটা বলো?
এই affidavit consent का है?
As far as the Vidyut Kumar Shaw is concerned, my lord.
ऐसे रखते हैं फाइल. Vidyut Kumar Shaw. Permission. How many consent are there?
My lord, three. Two consent is there, my lord. Two consent.
Poli and?
Poli and Vidyut, my lord. My lord, Vidyut's consent. What is there?
Poli का है.
ঠিক আছে.
মানে অ্যানেক্স আছে অরিজিনাল এটা আমার কাছে
হ্যাঁ আছে না সেটা ঠিক আছে সেটা তো এখানে আছে জজ সাহেবের কাছে আছে তো
Only no objection. Caveat. नहीं. No. Consent of police not here.
Only consent.
You persons are before a argument. You are not inspecting the record. Check the record.
It is before your lordship, my lord.
So suffering for the petitioner.
It is in the application, my lord.
Suffering for the plaintiff. The matter is fixed today for argument. But at the time of hearing, it is found that the affidavit of consent of one of the legal layer, namely
ওর আছে স্যার অ্যাপ্লিকেশনে আছে আমি বার করে দিচ্ছি পলিটানা
Poli Rana. Poli Rana is not available on record. Accordingly, the petitioner is, the plaintiff is given liberty to inspect the record.
My lord, it is my lord, your lordship, kindly take the copy. This is the copy, my lord, in the petition.
জিএ না এটা আমি যখন ফাইল করেছিলাম তখনই এফিডেভিট অফ কনসেন্ট এখানে বলেছে বোঝা যাচ্ছে না
Not available. New petitioner is given, plaintiff is given liberty to inspect the record.
Copy, my lord, the petition, my lord.
Full stop. Let the matter appear on 20 February 2020. Yes, next.
একটু রেকর্ডটা দেবেন তো আমাদের?
जरा उनको बुलाएगा मेरा
My lord, I am appearing on behalf of the petitioner, my lord. In order to assist the honorable court, I have prepared a list of dates.
What is the name of the testator?
Yes, Munindranath Sanyal, my lord. That's the very first.
Sanyal.
Yes.
Where is the will?
Will is
solemn form.
Yes, yes. Will is in Bengali, and there is a translation
Where is the name
also.
of the testator in the will, executor in the will?
There are two sons of the testator, my lord.
And
one is the propounder. I'm telling.
Where is that? Hereby
Mrinmoy and Tonmoy, my lord.
correct. Where is the executor? Appointed executor.
One of the son.
Where is that? Where is that?
That is.
Where is
I'm
that
showing.
in the
I'm showing, my lord. Mrinmoy and Mittur por.
Yes.
My lord, see Mrinmoy Sanlal, that is in page 5. Yes, yes.
Correct.
Yes. Now.
So how many, when he died? Date of death?
Date of death is, that is also, I have recorded in the list of dates, my lord.
That is exhibited. Death certificate is exhibited or not?
16 to 2022.
16 to 2022.
Yes,
what
my
about
lord.
his wife?
He died, he predeceased.
How many legal heirs?
Two only. Only two. One is the propounder and another is another son. And the matter remains uncontested, my lord.
Where is the averment with regard to the wife, sir?
In the will.
No, in your application, she was the predeceased to the testator.
Just a moment.
Mother and wife of the deceased, predeceased. Yes. Paragraph 3. Yes. Then, how many, what about the...
There are two sons, my lord.
What about the attesting witnesses?
Yes. Attesting witnesses, my lord. I have given the list of dates. If your lordships kindly sees to that. On 4th March 2022, executor being one of the beneficiaries under the son of the testator of the will filed this present.
Correct. That's how you've gone through.
Yes.
I wanted the attesting witness evidence.
Yes. Attesting witness, my lord, although they have been noticed, but they did not come, my lord. So in that prevailing circumstances, we send notice to the attending witnesses, my lord, not the attesting. At the first, there was attesting witness was noticed, and then attested witness did not come, and so the attending witnesses, there are two attending witnesses deposed before this honorable court, my lord.
Two attending witnesses?
Yes, my lord.
What are the names?
My lord, there are two, my lord. One is Rahul Sanyal.
Rahul Sanyal.
Yes, my lord. Another one is Vishwajit Das, my lord.
Yes.
Rahul Sanyal is a nephew, my lord.
Rahul Sanyal is nephew.
Yes. He could not identify the signature of the attesting witness, my lord. Identified the executor, but did not identify.
How the Biswajit Basu has.
Yes. He's the second witness. My lord, kindly see this. He has given exhaustive answers.
So appearing for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated.
Testament dated, my lord, this is 7 October 2021.
7th October.
My lord, this is a registered will.
7th October.
7th October.
7th October 2021 of the testator Manindra Nath Sanyal. Counsel for the petition submitted. The testator has executed his last will and testament by appointing the petitioner as sole executor of the last will and testament. The testator died, leaving behind two sons, that is the petitioner herein, and another is one Mr. Tanmay Sanyal. Full stop. The wife of the testator was predeceased to the testator. Counsel for the petition submitted. Though the testator had executed his last will and testament in presence of two attesting witnesses, but in spite of notice, the two attesting witnesses has not come forward to give evidence or filed affidavit. Accordingly, the petitioner, to prove the will, has examined two attending witnesses, namely Rahul Sanyal and Biswajit Das. Counsel for the petition submitted. Both the attesting and the attending witness, namely Rahul Sanyal, in his evidence has categorically stated that the testator has executed his last will and testament in his presence by appointing the petitioner as sole executor. Full stop. The another attending witness, stated that the testator executed his last will and testament in his presence by appointing the petitioner as sole executor, and the another attending witness has also categorically stated that the testator has executed his last will and testament in his presence and in presence of two attesting witnesses, and he has identified the signature of the testator as well as the attending witness of the will in the said will. Full stop. Counsel for the petitioner submitted. The petitioner has proved the will and is entitled to get the probate. At the learned counsel for the petitioner produce the original will, death certificate of the testator who died on 6th February 2022, leaving behind the two legal heirs, that is the petitioner and the another son, Mr. Tanmay Sanyal. Full stop. Mr. Tanmay Sanyal has given his consent, stating that he has no objection for grant of probate of the last will and testament in favor of the petitioner. Though the two attesting witnesses are not appeared before this court in spite of the notice, accordingly to prove the will, the petitioner has examined the two attending witnesses, and both the attending witnesses have in their evidence before this court in solemn form has categorically stated that the testator has executed his last will and testament in their presence by appointing the petitioner as sole executor of his last will and testament in presence of two attesting witnesses. Considering the above, this court finds the petitioner has proved the will and is entitled to get the probate. Accordingly, the department is directed to issue probate of the last will and testament dated 7th October 2021 on completion of all formalities. At the time of grant of probate, the copy of the will be made part of the probate. PLA number 112 of 2022 is disposed of.
Malad, obliged.
Yes. Call.
My lord, I'm led by Advocate Nikita Tulsian. She's addressing before some other court. Kindly praying for a short passover.
Why?
For 10, 5
What
to
is the
10.
GA1? What is the GA1?
GA1 is about, Your Honor, Your Lordship, it's
Ad
about
valorem court fee paid by the petitioner 50,000 in PLA number be returned to the petitioner. Why?
it is in connection with the PLA 162 of 22, my lord. The stamp duty is of 50,000 is kept with the record of
Okay.
PLA.
Asu.
Obliged, Your
I appear on behalf of the respondent. Defendant.
And may I submit with your lordship? This is an amendment application to the APD of assets, my lord. What has happened, my lord?
You are for the plaintiff.
I am for the plaintiff.
You are for the defendant.
Defendants, rather. They are what is one side. I am alone.
There are two amendment applications.
There is a latter one. Mine is a prior one.
You also
and that
filed
was
your-
hard out. Actually, my application was hard out. Thereafter, they filed an application. But that bench is now shifted here. So, my lord, may I tell you, lordship, what has happened? Some of the assets have been not mentioned therein, and some assets have been mentioned wrongly, which doesn't include the name of the testator. Well, may I tell you, lordship, what are those?
So you are having any objection for
Yes, I have filed opposition, my lord.
And what is your object? What is
Uh,
your affidavit?
The basic crux is
Bringing the affidavit of assets in the affidavit. What is the objection on that?
the issue is, my lord, the entire property of the deceased, his wife's property is also incorporated.
Wanted to bring on record. Okay.
That's right. We want to delete that. So wrongly done by the other advocate. I not say wrongly, sorry, Lord. But done mistakenly. So now this needs to be corrected. Some of the properties which have not been mentioned, that should be incorporated. And some of the monies which are lying at different places, those have to be incorporated. This is my application. Lordship takes up
Money
my
in the name of the deceased.
deceased.
A GA number?
1 of 2021.
Yes.
Your Lordship takes up this paragraph 3, my lord, of the petition.
Yes.
No, my lord.
Paragraph 3.
Paragraph 3 of my petition, lord.
Yes.
That the petition so-and-so number could not mention about certain properties and assets lying in the name of the deceased above named, as the existence of the same was unknown to the petitioner at the relevant time. Your petitioner hereunder states the details of such assets. These are the number one is the 60% share in the farm. There is already an award which is pending here because state has challenged the award. And I think the amount would not be less than, after with the interest, is more than 4 or 5 crores.
Partnership firm in the name
Partnership,
of the deceased.
Mrs. Kalipodabad. The rest is all the daughters. The 4 daughters are fighting now. The next is fixed deposit. Saving certificate.
In the name of the deceased.
In the name of the deceased.
Okay.
That has been mentioned here. All in name of the deceased.
Saving certificate. 500 rupees.
These are all movable assets.
Yes.
Now, I'm going to kindly come to paragraph 4. It was a property which was already gifted long back in the name of one of the daughter. So there is a suit pending challenging the deed of gift. So naturally, this ought to be excluded there. That the petitioner has in the affidavit of assets affirmed by the petitioner filed with the application number so-and-so, mention about an immovable property being a piece and parcel of land measuring 0.110 acre together with buildings situate lying at so-and-so, the Bankura district, measuring about 0.110 acres with the same a little more or less, well, about 80 lakhs rupees. This we want to be deleted because the property doesn't stand in the name of the deceased. He has already gifted to my client, and there is a suit filed by my land friend's client challenging the gift after the death of the father, naturally. So that's pending. So naturally, but this cannot be included in the affidavit of assets.
So that is by way of gift.
By way of a gift. Okay. Long back in 2014 or 15 or 16. Now, Lord, kindly come to paragraph 6.
No, where you mention.
Lordship, Lord.
The inclusion movable has been a mistake. The same should be excluded. Where you mention why it is to be excluded? You're not mentioning there.
That's a farm so and so mentioned about an immovable property together so and so.
Now you stated that it has been
With the
given to
stability.
you by way of a
That's
deed
a
of
paragraph.
gift.
Lordship is in paragraph 4. Then
Ah.
kindly come to next paragraph, Lord,
Hmm.
which was just going to place it.
Hmm.
That your petition states that the inclusion of the said immovable property has been an inadvertent mistake, and that the same should be excluded from the epidemic assets.
Correct. So you
So
have not
that's what.
disclosed the document.
About
You
the
could have been disclosed the document, the deed of gift.
deed of gift.
Yes,
That
and
was
you have to mention in the
that we had
affidavit.
admitted in opposition is pending.
Admitted.
Admitted. The suit is pending. It's not that disputed. The suit is pending. Probably evidences might have been going there. I don't know about that. That's pending in the Makuda. Now, my lord, kindly come to paragraph 6. That your petitioner further states that due to ignorance, the following properties have been excluded from the epidemic assets, and that the same has to be included therein, and the details of which are stated as follows. All that piece and parcel land measuring about 8 katas with stability so and so, 4-storied building, lying at so and so Makuda. Now, my lord, this is one property. Then the second one, 33, not Chetaks, my lord, that should have been decimal. Not Chetaks, 33 decimal. That's a mistake there in the typing. Equivalent to 1 bigha. Chetaks cannot be, 33 cannot be equal to 1 bigha. 33 decimal naturally. So I said Mauja, so and so at Makuda. This also. These two properties are to be
So
included.
you want the two properties to be added, one property is to be deleted, and with regard to the immovable property,
Immovable properties.
movable property is to be bring on record.
Well,
These are the
I think I was just talking to my junior also, and he has a talk with the lady also. There are various other dues. So I said, why not getting a receiver appointed to collect this matter? They are residing in Makuda, so naturally, no communications, nothing at all. This happens. Naturally, this might have been committed mistake by the previous learned advocate record also. Now, my lord, this has been marked the same with the rate, which is marked as Annexure A. We have also included that in our petition, epidemic to assets also. These we, my lord, wanted. If your lordship now kindly looks to their reply. Now, my lord, before that, they have challenged it. And my lord, I have also kindly come to paragraph 9, just for a moment, my lord. That your petition further states that the amendment sought for are normal in nature, the same would be in no way affect the character of the application being so and so. Then will kindly come to their opposition, my lord, by a said, my lord, that they have admitted it. If your lordship kindly come to their reply.
Opposition.
Opposition. Correct. Thank you. Paragraph 6, my lord. 6 onwards. Oh, sorry.
Original नहीं है. You not filed?
Yes, I have filed.
Yes, my lord, I have filed also replied.
Yes.
Is it available now?
That copy is there. Original is not here. Yes.
Last occasion, probably it would not be traced. I have
given that. Yes.
Before Justice Patanaik. Anyway, kindly come to paragraph 6. The deceased had 60% share in the partnership business, so and so. The 4 daughters, so and so story. There is a pending arbitration proceeding in connection with said business that's now completed.
That has completed. Execution has started. They have accepted the execution. Some portion also has given. I am told by them.
It's just the incorrect submission. Sorry, my lord. I don't want to say about it. 34 is pending prior to that. 36(2) has already been filed.
So there is no stay. There is no stay in.
There is already a stay order subject. There is already a stay order subject to satisfaction of London District Judge. It's in the commercial code. They have filed the execution commercial code Asansol. That's the difference. So that's pending commercial execution here also pending, and there is an appeal pending challenging the jurisdiction of the landed commercial code at Asansol.
So award in whose favor?
In my favor.
Though I am the claimant, award is
in my favor, but there is no stay from any forum, my lord. If my lord so desires, I can reproduce those orders from before
36(2). There is an order. I'll let me take it from me because I moved that 36(2). They are at Alipur.
36(2) stay is granted.
Stay granted subject to satisfaction of the landed district judge. Before the landed district judge at Alipur. So I'll have to go there but there have been some obvious mistakes in the order. Old sections, unamended sections, and some other mistakes have cropped up. So file an application for amendment or correction of this order, so that it could be corrected and remitted to the land registry again, for the purpose of sending it to the land registry. So kindly come to paragraph 6 there. Then the petitioner said this. Then paragraph 7, my lord.
So you are the claimant before the arbitrator.
Before the arbitrator.
So you lost.
I lost it.
And they got the award.
They got the award. But I will not open my mouth about it since 34 is pending.
No, that's
why 34 is pending. That will be decided there.
So let it be decided. So what would be what this court will do with regard to that award amount?
This is nothing here.
Nothing.
Nothing here.
So why
this is a probate application.
So that's why you want to bring here?
They have said it. I have not said it.
You have filed.
They said it. Opposition is there.
No, you have stated.
No, he has stated, but you.
Yes.
This is
I want to, because the entire properties, whatever late Kalipadobad had been given to my client. So naturally that has to be brought in. The 60% share.
That's why the 60% share in the partnership. This is the partnership from with regard to the award.
That was not the award in that favor. Award is a pretty peculiar one. The award is that as if I have siphoned up the money. So I have to deposit the money back in the farm's account.
What the award is passed? What the arbitrator has held?
Held that as if we have removed certain amount from the farm's account, but I will not open my mouth about 34 application, but that's another challenge. And that's the reason I have been directed to deposit back the amount. And that's under challenge.
So that will be decided when why you want to bring all these things?
Because the share has to be said so. Share has to be said.
Once the deed, once the partner, the application is decided, how this court will decide the share? Only this court will grant the probate.
That's all.
And the probate is you are not disclosed it is not the property. You already gone to the arbitration. Arbitration has already decided. So what the this court will do now?
That's a different chapter, Lord. At the moment, what I'm saying, Lord, that supposing 60% shares were given to me, and I succeed in the probate. Let us think about it. So naturally, even if I deposit this money, say supposing I'm in direct deposit, so naturally 60% plus 10%. That is 70% money would be mine. Am I correct to your lordship? So that's the reason I brought in that this is also to be included in the probate proceeding.
Okay.
But that belongs to the naturally.
Yes. Next.
Now the paragraph 7 they said the delay of 2 years they are they are alleging it. Yes, it's 1990. It was filed, but within 2 years we have filed this application, and their application is after 5 years. Their amendment application.
When you came to know about this partnership, this amount, you had the knowledge with regard to this?
Nothing at all. She's a lady.
You
used to reside in Kolkata. This is mere allegation. What has been made?
You have filed this application 2021. When you came to know about this partnership?
No, partnership was then pending.
You had
when I filed it, when we filed it, then arbitration was pending.
Okay.
Next. Then what the paragraph 8. No, Miller, sorry. Paragraph 7, I didn't place it. Then if your lordship come to the second line, I state no reasons or explanations given such delayed application. I further state no specific reasons are given. I state the plot of land measuring 8 kathas along with the building standing there is subject matter of title suit number so-and-so 105/2019 pending before the Court of Civil Judge Senior Division. Bankura. This is a partition suit filed by the respondents. The petitioner is contesting the same. But the property belongs to Kalipadobad. There might have been a partition suit, but this has to be brought within the probate proceedings because the properties have been given under the deed itself. Will itself. So if the will is granted, naturally entire properties of late Kalipadobad has to be brought in within the order itself.
No, deed is prior to the will or after the will?
The will is prior one.
Will is prior.
After
the deed.
Will is prior one. Gift is almost thereafter.
Deed will prevail.
Probate.
Deed will prevail if it after the will.
Naturally, deed will prevail.
Then
this is different. This property is different. This property is 8 kathas property. They have filed a suit for partition. I am saying this property stands in the name of Kalipadobad. If I succeed in the probate proceedings, naturally this property will belong to me. So if I lose it, naturally partition suit will continue. But if I get it, supposing probate, I am getting the probate. So naturally this property will come to it. It has to be included.
Okay,
Then
next.
the next one, paragraph 8. This is a gift. So I denied this. Third line, Lord. I state that no reasons express the same line. Then I further state that the plot of land measuring 110 acres, along with the building standing thereon, in Jogeshpolli, is subject matter of title suit number so-and-so, pending before the court of so-and-so. The respondents have filed the said suit challenging the alleged deed of gift in favor of the petitioner in respect to said premises. The petitioners contested the same. This is exactly the gift. So naturally, this has to be excluded. This property does not stand in the name of the testator at all. So it has to be excluded. But the other properties which I have mentioned is naturally has to be included.
Yes.
Then paragraph 9, that the property which I wanted to bring in, that so far as the piece and parcel of land is measuring about 33 decimal, so and so is the owner of 2/3 portion. Correctly? What exactly I have said so? 33 decimal land belongs to the Kalipada Bagh. 11 decimal land belongs to wife. Wife has not paid any will. She is also no more. After 2 months, she has also died now. His wife, maybe so-and-so, was the owner of balance 1/3 portion. This fact is and same has been admitted by so-and-so. So this is no difference about it. So we wanted to bring this 33 decimal of land. That since this is one property stands in the name of the testator, it has to be brought in within the period of assets. So these are the things that I've filed the reply. I'm not placing the reply, actually only dealing with those submissions we have done. Now, since my land firm has taken up this issue of delay, I have referred to 3 judgments already disclosed. I think those judgments are available here. Sorry, my lord, it's 125 now. But I have already taken over the lordship different time, my lord.
Yes, 2 judgments are there.
3.
2015, volume 13.
9.
2009. No,
2012 CWN.
दूसरा है क्या देखो?
CLJ, sorry. And there is SCC 2015.
अच्छा, 2009, volume 10. इसको
Volume
pin
10.
करो.
SCC.
2009 and another is Calcutta Law Journal.
Calcutta Law Journal. And another is 2015.
What are the points here?
But it's now 125. It's lordship time.
Complete and then
complete. Very well. 2009, Lord, if your lordship statement kindly come to paragraph 5, 6, and 7.
2009.
2009, volume 10, SCC 626.
Yes.
But 3 paragraphs I will just place before lordships, 5, 6, and 7. As noted herein earlier, the prayer for amendment was refused by the High Court on 2 grounds. So far as the first ground is concerned, that is the prayer for amendment was a belated one. We are of the view that even if it was belated, then also the question that needs to be decided is to see whether by allowing the amendment, the real controversy between the parties may be resolved. It's well settled that under Order 617 of the Code of Civil Procedure, wide powers and unfettered discretion have been conferred with the court to allow amendment of the pleadings to a party in such a manner and on such terms as it appears to the court just and proper. Even if such an application for amendment of the plaint was filed belatedly, such belated amendment cannot be refused. Though here is no delay, within 2 years in file. Yes. It can be, then also it includes the COVID period also. Then the next paragraph 6, your lordship find, next line, last line of the said paragraph. Therefore, in our view, mere delay and latches in making the application of amendment cannot be a ground to refuse amendment. Then paragraph 6. I'm not reading the first portion, second line, the second sentence. Accordingly, we do not find any reason to hold that only because there was some delay in filing the application of amendment of the plaint, such prayer for amendment cannot be allowed. Then paragraph 7. So far as the second ground is concerned, that is the prayer for amendment of plaint, if allowed, shall change the nature and character of the suit. We are unable to accept this view of the High Court. We have carefully examined the amendment prayed for, and after going through the application for amendment of the plaint, we are of the view that the question of changing the nature and character of the suit, if amendment is allowed, cannot arise at all. The suit has been filed for eviction inter alia on the ground of various plaint. It cannot be disputed that even after amendment, the suit would remain a suit for eviction. Therefore, we are unable to agree that if the amendment of the plaint is allowed, the nature and character of suit shall be changed. Accordingly, the High Court was not justified in holding that the nature and character of suit shall be changed if such prayer for amendment is allowed. So these are all in my favor, my lord. That's what Order 6, Rule 17 also says.
Yes.
So now, my lord, kindly come to the next judgment. That is.
Yes, I have gone through all. That is a very demand. Yes.
Lord.
What is your objection?
2 points, my lord. Kindly comes to.
Come on the next day. So suffering for the plaintiff, so suffering for. It is not. It has been just defendants. Full stop. Counsel for the plaintiff has argued the matter in connection with the application being GA1 of 2021. Full stop. Due to paucity of time, common defendants could not be argued. Let the matter appear tomorrow. Tomorrow.
If my lord, tomorrow I have some fixed matters, my lord.
Then day tomorrow, day after tomorrow.
Then let the matter appear on 18th.
By 18th, I am not here, my lord. Kindly, my lord. Kindly, my lord, not 18th. Next Thursday or Friday itself.
On 21.
Deeply obliged.
21st.
Deeply obliged.
My lord, just trouble your lordship for a minute. My lord, this was the order that was passed. The item number, 54. 54. The first order.
Yes.
My lord, your lordship had given me liberty to file an objection to the affidavit.
Report of the master written and made in the proposal applicant. This court is of the view the proposal application.
To file an opposition.
Be registered in the page before this. All parties. Yes.
Now, my lord, no, but difficulty in this, my lord, the test is the caveatrix, my lord, is the mother whose affidavit I have prepared. Now, my lord, she is 95 years old. She wants to affirm it by way of through a constituted attorney, that is her grandson. Now, my lord, generally when constituted attorneys do, my lord, the affidavit has to be of that person. Only the constituted attorney signs it through the pen. Now, my lord, the department is refusing to accept this affidavit on the ground that it should be the affidavit of the constituted attorney. Constituted attorney cannot depose on behalf of the EA.
My lord, to this, my lord, I am opposing, my lord. Now, at this stage, my learned friend is not entitled to seek any liberty from this honorable court because already I have filed an application for discharge of the caveat, which was filed out of the time and on the false pretext, my lord. My application GA number 1 is pending. Now, on 14th of June, my lord, the constituted attorney has lodged a caveat saying that no citation was issued and that a certificate has been issued by the learned registrar. Thereafter, I have taken out the application. In my application, I have been able to demonstrate, my lord, that despite the knowledge of the probate proceedings, my lord, having been participated, no caveat has been filed, nor any application has been filed, despite the leave being granted. First of all, your lordship will hear my application. Thereafter, your lordship will give necessary direction if at all my learned friend is entitled to in the law. It is a pure question of law. Such a liberty cannot be granted. This is the other way, circuitous way to have the affidavit in support of caveat being introduced in the proceeding, my lord, which my learned friend is not entitled to under the law.
Very well, my lord. If that is my learned friend's content,
let my application be heard first.
Let it be affirmed and let it be accepted after my.
No, my lord, I oppose to that. It cannot be affirmed even now.
What is your application?
My application is GA1 is for grant of probate and for discharge of the caveat which has been filed wrongfully before this honorable court.
Who filed?
Viswajit Addi, my lord, the constituted attorney has filed. My application is there, my lord. GA1.
Viswajit Addi. I appoint him as a constituted attorney for the purpose of swearing.
Shivan কোথায়?
GA1 in master summons.
Master. In light of my application, my lord, this leave cannot be granted.
Dutt, where is the attorney?
The caveat
power of attorney. Power of attorney. It's there.
Do one thing.
Yes.
Do one thing. If you are having the power of attorney, you come with the as an attorney, not by her.
No, my lord. What is this, my lord? This mother, my lord, her son has passed away. So mother has got a caveatable interest.
Correct.
Now mother is trying to oppose the will.
Correct.
So, my lord, she has to give the grounds.
Correct.
Now, if it is the affidavit of Biswajit Addi, then he will have to say that my grandmother said to me, these are the grounds.
Correct.
That would become hearsay. That would not.
Correct.
So, what generally we do is, my lord, the affidavit has to be by that person. It has to be read over and explained to her, and the Biswajit Addi will sign on behalf of it. Otherwise, this objection will remain.
My lord, I will not educate my learned friend. There are other ways and means where affidavit can be affirmed even by way of commission.
Your lordship wanted
It
to
can
say
be
the
done by way of commission.
Let me see.
Yes. बोले दिए तो जाने he wants to do it in a circuitous way. He wants to introduce the affidavit. Yes. Let my application be heard first. Such leave cannot be granted, my lord. Let him take out an application. Leave was granted in month of May 2024. Such leave was granted. Today we are in February 2005.
So that is not for my learned friend to say my application should be dismissed. I have filed an application.
That application is not appearing today. You have no locus today. You have no locus today. You can't seek any leave. You have no locus. You have no locus.
I am not asking for leave to accept it. I mean,
without their application, how your GA1 can be
My
taken
lord,
into
yes.
consideration for discharge of the caveat?
Yeah,
Court has to consider all
My
applications
lord,
together.
their caveat, my lord, what has been done, my lord, that in the month of, my lord, I tell your lordship, that my learned friend client has filed a suit before the Alipur court. There, my lord, we had brought into their knowledge that the PLA proceeding is pending, my lord, probate proceeding.
Where?
Before this honorable court.
Correct.
Thereafter, my lord, we had mentioned the matter for grant of probate.
Yeah.
Here. Then, my lord, at that point of time, my lord, my learned friend interfered, appeared before in the probate proceedings, and my lord, this honorable court directed my client, my lord, to serve the copy of the probate petition upon my learned friend.
Correct.
In course of the day, that was being done.
When
This-
it was served?
It was served on 29th of April 2024.
April 24.
Thereafter, my lord, this honorable court granted them liberty to file wakalatnama. That wakalatnama was not filed, my lord.
Correct.
Thereafter, my lord, they took the plea that the name of the lady or the mother has been spelled out wrong. Therefore, it should be Ila and not Ila. Then, my lord, court said that very well, you take out an appropriate application explaining everything. Court granted them the liberty on 13th of May 2024. And today, my lord, we are in February 2025. This application has been taken out by me, my lord, because after losing of this so-called caveat, my lord, under the original side rules, my lord, they had to notify the advocate, my lord, that caveat has been lost.
Correct.
No such notification has been made, my lord. It has not been notified. However, my lord,
have you received the caveat?
No, we have not received the caveat. Now, my lord, we have obtained a certificate because the probate was not being granted. We went to the department, my lord. From the department, we came to know that such a caveat is sought to be lodged on 14th of June 2024. Then, my lord, we obtained a certificate from the learned registrar, my lord. The learned registrar had issued a certificate to the effect that an undertaking has been given by Biswajit Addi, claiming himself to be the constituted attorney of the lady, saying that no citation has been received by caveatrix till 14th of June 2024 through her advocate. However, she has not filed her affidavit in support of the caveat. Now, my lord, in light of that certificate, my lord, annexing all the orders and the documents, my lord, I have taken out an application being GA number 1 of 2024. Notice to this application has also been given to my learned friend, my lord. This application is being heard by your lordship. I shall show to your lordship that the law...
What is it done? Not disposed of?
No, that is pending. Until unless this is being disposed of. And my lord, no leave can be granted by your lordship either to file application or to file any affidavit in support of the caveat.
Your application? What are the ground in your GA1?
My application is this, that the first of all, my 14 June 2024, the caveat that has been filed is liable to be discharged because it has not been filed in accordance with the original side rules. This is first. It has to be filed within 8 days. The middle of 29, if I take the date of the knowledge from 29th of April, also the 8 day expires long before. My lord, it's a mandatory rule.
When your matter is fixed?
It is today only, but it is appearing
Listed?
today.
Which matter?
54.
Application is also there.
What do you have?
The purchaser. Technically, I also have caveatable interest, but that's what. And the purchase of the property of the testator. So technically, my lord, in view of 2008 Supreme Court, I have caveatable interest.
But my application is otherwise. But I am between the devil and the deep blue sea, so I have not been able to.
I told your lordship the last occasion, Mr. Moinak's versus client is in a soup because
And Milord, in
now
fact,
the will is being contested. At least attempted to be contested. My learned friend is trying to prevent the contest.
Attempted to be contested.
attempted to be
Because in the
contested.
eye of law, they
Milord, I am
say-
completely ready with the
You have
judgment.
already filed the application.
Yes, yes.
Saw the copy.
Yes,
Affidavit
No,
completed.
they have not solved it.
My learned friend has no locus to have the copy.
Okay, Mr.
But
Natat, I will do one thing. I will do let her satisfaction with regard to 54. Let the 54 come on list. Let me hear. If I find, then automatically you will get the
Yes.
chance.
Yes. Deeply obliged, Milord.
আমাদের সার্ভিস করেছো তো না না এই অ্যাপ্লিকেশনটা very well
That will be better.
Milord, kindly
yes,
fix
yes,
this
Milord.
matter, Milord, because every day, Milord,
54
otherwise.
now already I reached 50.
Very
It will come out.
Yeah, both the GAs are appearing. Both the GAs are
54.
appearing.
All matters are ready. I am also ready. What can be done? Witness action is relaxed action.
Yes. For the up to 140, my lord, is here. Yes. 10 minutes more than the normal time. And 10 minutes there.
Yes, witness present.
Normal time data. Data, 1:30 is the normal time in this court. So that he's saying 25 minutes. You know, that is official time. This is normal time is 1:30 daily. This
Really, because
PLA matters.
PLA matters. Otherwise, it is very difficult.
And is somebody is a frugal eater.
No, but Milord, we are very obliged that PLA matters are now being disposed of, taken up after a very long time, because the Lordship has scheduled it 1 hour every day.
That's why
PLA matters are
That's why I'm taking till 1:30 because 1 hour can be given.
1 hour can be given.
Can
10,
be
15
given.
matters.
I can adjust 10 minutes to the litigants
But
of
again,
this.
criminal.
Yes, now the
that will, I think it will be very fast, but very difficult.
Yes,
criminal revision.
I don't know how the time it will be adjusted.
Criminal revision.
Maybe your Lordship's great prowess will make it fast, but
No, the best time is 3 p.m. every Friday. That we had the execution. The execution is one bench Friday from 3 o'clock. For last 6 months, no execution
Nothing
taken.
will happen.
Nothing. For last 6 months, no easy matter. So,
Because earlier I have been given some appellate side
345.
matter, so I am taking 345, but so that has been completed within 2 months.
2 months.
all my lord, my lord will kindly not complete.
Yes. May I start?
Continue.
Yes, sir.
The witness he's already under oath.
Yes, he's midst of the cross.
Cross resumed, huh? Cross, na?
My lord, cross.
Cross resumed.
The defendant number 2. Mr. Bhattacharya, as per the sanction plan of the building, what is the nature of use with regard to the ground floor?
It's car parking.
Car parking.
Car parking.
Car parking.
It's car parking.
And what is the nature of use of the first floor?
It's commercial. It's assembly actually. It's
For commercial purpose, assembly?
assembly, sir. It's termed assembly. If you see the sanction plan, it's assembly.
Assembly.
It's termed assembly.
In the
Termed assembly.
commercial, in the sanction plan, is termed as assembly. And what is the nature of use of the rest of the floors, that is from the 2nd floor to the 5th floor of the property?
Residential.
Residential. Before selling the portion of the 1st floor and the 2nd floor of the property to respondent number 1, sorry, defendant number 1, that is United Vein Care Cancer Research Institute Limited, did you, as the developer, obtained permission or a no objection certificate from the fire department?
But I object to this, my lord. I would request my witness to step out.
What is the question?
He was the developer of the property. My question is, before selling the property, did you obtain fire license?
My lord, the only objection is that.
Please.
No, then kindly, my lord, kindly.
Let him.
I said that the witness should step out.
Yeah, please.
By the
Outside, sir.
suitable or he has not tutored the witness to that extent.
No, but I must know the case from the plain.
Okay, he
That
is
is
well
all.
aware of this. He is well aware of your witness.
Lordship will kindly mark it, my lord, with objection.
Question repeat.
So the process, how a building is sanctioned.
No, please answer in yes or no and then explain.
This is with objection.
Please answer in yes or no and then explain.
Have you obtained the
Yes.
Yes.
Kindly
Within bracket.
Yes.
The plaintiff raise objection.
No, the defendant number two.
So defendant number 1 has raised objection. 2.
Yes.
Defendant number 2 has raised objection as the said was not, as the plaintiff has not taken the said defense in the plaint.
The plaintiff has not pleaded.
Pleaded the same in the plaint.
case.
Pleaded the same in the plaint.
Kindly produce the original of the said no objection
It is there at the back of the sanction plan.
certificate
obtained from the
fire department.
Fire department. Answer. That is available in the back side of the sanction plan.
Your Lordship, if I may take 1 second, since I'm
Yes,
a builder.
you can say.
The process is when you
Witness volunteers.
The process is when you take a sanction of a G+5 building, you have to have.
The process is when you take sanction of G+5 building.
G+5 building, you have to take a provisional NOC from the fire department. And once any commercial institution starts operating or decides to start, they have to take a separate sanction depending on the nature of the business. So fire sanction,
Different fire sanction.
depending on the nature of the business. For example, a restaurant is different.
For different sanction, for example, restaurant is different.
Medical place is different.
Medical place is different.
Our responsibility is to sell with the necessary municipal sanctions, and the person using the building, because we don't know what the person will use it for.
And the person using the building
is
having the responsibility to obtain such certificate from the
obtain
concerned
all the other necessary permissions required from the various departments.
Yes.
Exhibit D tag with them. Shown Exhibit D, which is the sanction building plan. Kindly indicate the portion from the sanction building plan which records the permission from the provisional NOC from the fire department. Sorry.
This is not the copy of the sanction plan. Sorry.
उत्तरটা লিখেছেন?
Sorry,
This is not the
I
copy of the
stand
sanction-
corrected.
Okay, ঠিক আছে.
This is not the copy of the sanction plan. Then after further going through the sanction plan, witness
The
submit-
fire
state
NOC, provisional NOC, should be part of the thing. It's not pasted here, perhaps should be in the file.
Of this document, but
We can produce it as and when it is required because it's a public document.
As in, আস্তে আস্তে যেতে হয়। Go slow.
as and
যাবে না
when
কিছুই।
it is required, because as it is a public document. উত্তরটা গেল। But his answer, I think he withdrew his answer.
চুপ বসো, তুমি disturb করো না। আমি জানি, cancel করতে আমি I know. Please.
Not document.
What is recorded?
একটু বলে দাও তো।
What we can produce it as it is required public document.
As when
As and when it required.
As it is.
And when it required, as this is the public document.
Kindly produce this provisional no objection certificate on the next date. Yes, bolo. I will. ठीक है.
So this is also subject to objection, my lord, for the same
No,
reason.
he volunteered that he will produce.
With objection.
With objection. Mr. Bhattacharya, if I say that in terms of the development agreement, the developer, that is you, could not have parted possession of any portion of the property under the developer's allocation without giving possession to the owner's allocation. Will you be in a position to contradict me?
The owners were given allocation and they are in possession of their shares as of today from that day itself.
From that day
itself. The physical possession of all the owners' allocation are with the owners.
From open quote, that day itself, close quote.
Before,
please.
Which date you meant?
I cannot quote a date, but by the time I handed over possession to outsiders, the owners had also received their possession.
তুমি এসো at the time of handing over possession of the owner's allocation area, the parties must have entered into documentation.
Keys were handed over. It still lies with the owners.
So I take it that there is no documentary evidence to substantiate your answer that possession of the owner's allocated areas were handed over to the owners.
I cannot recall.
Do you recall that in terms of the memorandum of meeting dated 28th of January 2008, the first floor of the building, which was sanctioned as commercial, was to be sold, and the sale proceeds was to be distributed in equal share amongst you and the owner?
It was a 50-50 allocation.
I take it that when you sold a portion of the first floor to defendant number 1, you had paid the 50% of the consideration to the owners?
In kind, because 50% is still lying with them. 50% is still lying with them. So they are in possession of the 50%.
So you admit that in terms of that, so you admit that you did not reimburse the 50% money that you received from the sale of a portion of the first floor property, first floor flat, to the owners.
If 50% is unsold, a reimbursement happens either in cash or in kind. So in kind, they are holding on to 50% of the place. On to 50% of the place.
No, 7.6. Exhibit. Next second. Exhibit. No. Exhibit A. Shown Exhibit A, particularly clause 7B, 7.6 bracket B, at internal page 17. can you please indicate the clause from this development agreement where the parties agreed that the 50% share of the first floor will not be reimbursed in money and will be adjusted in kind, as you deposed in your last answer?
This primarily deals with possession of the developer's allocation till such time the owners are given possession of the owner's allocation. This doesn't talk about distribution. Till the time the owners are giving possession of the owner's allocation. This doesn't talk about allocation or any financial settlement or space-wise.
Does this document, does any clause of this document records that the devil that you are, that you will be, you can adjust.
Sir, I have to go through the entire document to answer.
You can adjust 50% share of the first floor of the owner's share in kind.
This document says that 50% of the first floor belongs to the owner and 50% to the developer. So it automatically means, this document says that 50% of the allocation belongs to the developer and 50% to the owner. It automatically means that either in space or in cash. That's my interpretation, of course.
Did the parties enter into any subsequent understanding after the development agreement with regard to allocation of the shares and portions?
I cannot recall.
Exhibit C. Shown exhibit C. Do you now recall that this is the minutes signed by the parties on 28th of January 2008 after the development agreement, wherein the areas allocated to the parties were finally decided?
I do.
Do you find that clause 4, so clause 4 of the said minutes records that the sale proceeds of the first floor will be divided amongst the owner and the developer in equal share?
It is written here, but 50% of the space is unsold and remains with the owner.
So I take it that you have unilaterally went ahead to alter the terms of a written document.
No.
Did you inform the owners that you are in a process of selling the first floor, a portion of the first floor?
I had verbally, if I remember rightly.
What was the reaction from the, sorry. What was the reaction from the owners?
It's long back. I have no recollection.
If I say that the owners vehemently opposed to your action of selling the first floor, what do you say?
I say you're wrong. The owners had showed some objection in selling to a medical unit, not of selling. Not of selling.
So it is your evidence that the owners did raise an objection with regard to selling of the property.
Not selling of the property. But to whom it is being sold, to which I thought that since it's a 50-50, The owners did not have the right to, and still do not have the right to.
ঠিক করে লেখো এটা আনসার টু উইচ আই থট বলে কি এটা বললেন
হ্যাঁ সরি
না না সে আর বেশিক্ষণ হবে না তুমি আমার শিখিয়ে দেবে আস্তে আস্তে সরি
হয়ে যাবে
এই ডিস্টার্ব করো না সরি
which I even today believe, since বলেছেন উনি, which I even today believe that since the owner had 50% of the property, he had no right to do so. Exactly what he has said.
এবার শুনে
Rohit,
না না রোহিত
Yes.
গেছে সেটা পরে বলুন
হ্যাঁ দেখে না দেখে কোন দিয়ে
What he stated that on the record. Repeat the question.
Yes, I'll repeat.
Repeat the question.
I'll repeat. I had to go slow, otherwise not.
Repeat the question.
Hodgepodge হয়ে যাচ্ছে।
The owners had raised objection to who it is being sold, not to selling of the property.
Do you recall that whether these objections were verbal or in writing?
I don't.
You don't. Emailটা দেখে I'm showing you a document. This is not part of the any records. We have দাঁড়াও ভাই দাঁড়াও
একটা চিঠি করে ডিসক্লোজ করুন
নোটিস টু প্রডিউস নোটিস টু অ্যাডমিট ইন্সপেকশন সব দেয়া হয়েছে দিস ইজ নোটিস টু অ্যাডমিট দিস ইজ নোটিস টু প্রডিউস এন্ড দিস ইজ ইন্সপেকশন বসো বসো না দাঁড়াও না ভাই তুমি কেন ফটোপাটি করছো এতটা জীবনে আমার সঙ্গে জজ সাহেবের কপি হ্যাঁ যেটা বলি মনে হচ্ছে ওই যে আরেকটা ইমেল চিঠি ছিল না আমাদের সেই চিঠিটা কোথায় বের করতে
Yes. Yeah.
After shown an email
Give the copy.
ঠিক আছে কপি দিয়ে দিন ওদের সব ইমেলের কপি shown an email dated 11th of May 2010 as referred to in the notice no notice to produce but you will record that we have given this notice to produce and notice to admit which document for which document notice to produce and notice to admit dated 29th of January 2025 has been issued have been issued by the advocate on record of the plaintiff to the advocate on record of defendant number 2
on
date left side 29th of January and received by them on 30th of January.
Yes, what is the question?
Well, after receiving this email, I take it that you did not reply to the same?
I have no recollection of this email.
Yes. পরের এক্সিবিটটা দেখো তো একবার কত এক্সিবিট এফ না এক্সিবিট এফটা একবার দেখাবেন তো হ্যাঁ ইয়েস এক্সিবিট এফ shown exhibit F. Do you find that after the earlier email of 10th May 2010 written by the plaintiff to you, a follow-up email, a follow-up letter was also sent by the plaintiff to you on 1st March 2011.
Which part are you referring to of this letter which has been given to me? Which page number and which line?
Kindly see fifth line in the second para of this letter, which refers to the earlier letter of 11th of May 2010. Earlier email.
Yes, I've seen it.
Yes.
I have seen it.
And I also take it that you did not reply to the letter of 1st March 2011 also.
I have no recollection.
Malad, this letter, the notice to produce which I have given, this be marked as an exhibit. I'll tell you the reason, Malad. Question number 46. The witness has said that he has received this email in question number 46, last day.
Which witness?
This witness, yes. This witness.
Show the question.
No, that has already gone in.
Then?
That has already gone in, Joshua.
So what do you want now?
No, I want now this letter on the last day, this letter could not be marked as it because no notice to produce was given. He admits the email ID that has already gone in. Question number 43. Email ID is his email. He
43?
admitted. Yes, question 43. Question 42, 43. He has confirmed the email ID.
Anyone you have accessed the right to email?
42. What is your email ID? So 42 is the email ID he has confirmed. 43 is the email ID which he is using. Then 46 he says, I put it to you, and then these are two letters. One is 1st March 2011 and one is 11th May 2010. Now is 46. I put it to you that you had received the previous email dated 11th May 2010 as mentioned in the second para of the letter of March 2011. Yes, I have seen.
Correct.
So now he admits the receipt of this letter.
Correct.
The letter could not be exhibited at the last occasion because it was not.
I beg to differ. He didn't admit to the receipt. He said, I have no recollection. I think that is exactly what has gone in.
This is stated that as I have seen.
And this is Shravani Banerjee's letter. He has already adduced evidence. They missed the bus because they didn't produce this.
First is yes.
Being exhibit F.
Say anything.
Being exhibit F.
No, I put it to you. You have received the previous email.
46. I also put it to you that you had received the previous email letter dated 11th May.
So 11th May is one which I am handing over now.
As
mentioned in the letter of 1st March. So
March.
Received the previous email of 11th May 2010. So that is one which I handed over to now. So he says yes.
Yes.
And what is mentioned
put the question
he
on
has
that
only
way.
said that it is written.
Put the
I have
question
seen
on
this
that
not.
way.
He was not handed over this email on the last day.
Okay, that's it. Put the question on that way.
Yes. The deposition. No, but I'll just tell you. I've put a question. After receiving this letter, what steps you take? He said, I do not recall. So he did not read with this 46 and the last answer.
So that's why now first you have to bring the record of the document is to be exhibited.
Yes. So this document is an email which he has received.
So
I have shown him it.
Yes, to put the question. Sir, see the question number 4.
46. 46
through code. See the question number 46.
Sir, can I answer?
Yes. No, I am putting the see the question number.
I have
46.
seen it, sir.
Seen?
I have seen it.
Then you go through this email. Whether you are telling about this email.
Exhibit F and yes. And I've also shown him Exhibit F. Exhibit F refers to this email.
In 46, which you are saying, yes, are you saying in the Exhibit F, this is the email you have referred to?
Sir, these two emails, as I had mentioned in the earlier date, are our official, used to be our official emails. And I had not seen many of these emails. This is what I had mentioned in the last date also. So I have no recollection of this. I have read the particular line now. I have no recollection of this earlier.
Earlier email.
Earlier email.
So that now it can be marked as an exhibit because he admits that it is gone to his
Then
official.
again, you're not putting the questions.
Is issued by me. That's the difference.
Correct.
It's issued by
We
me.
have referred to. It has referred to in the exhibit F.
Exhibit is also mine exhibit.
Correct.
Exhibit F is also
Exhibit F
my
is referred.
yes, is also my letter.
Mail is also your.
Is my
So how you can exhibit through this witness, sir?
No, he has received it.
He's not the author.
He has not.
The recipient.
Yes, whether he let put the question as received or not.
Oh, no.
No, he has already said it.
No, he has said.
And
I'll put it.
I can't say anything.
No.
That's why.
Wait. I put it to you that you have received this email dated 11th of May 2010 in your email ID, which is Chirodeep, CHIRODEEP, B for Bombay, @gmail.com. Issued from the email of the plaintiff.
I have no recollection.
Now this can be marked as.
See the letter. See the email. Whether that email address to you.
He is not saying that. No, there is a না রিপ্লাই নেই প্রশ্ন করেছো আমার কপিটা বের করতে আটাই গেল
But this email is this Chirodeep B is mine.
this email ID Chirodeep
is appearing in the letter is of mine.
Is mine.
Fine.
Yes, next.
Well, now it can be marked. কি প্রশ্ন করবো? Where's no contents he can't say.
You missed the bus.
বল
You missed the bus. Mr. Mitro, this is electronics document. Electronics document has to be proved by the person who is in possession. And it is sent by, just a minute, it has been sent by you. He is not telling if he stated that I have received, then the court.
No, he has not denied.
Not denied, I did not recollect. So how the court can assume that not recollect is the admission? And at the time of evidence of your plaintiff,
that was not done.
You're not done.
That was not done. That at that time, that team was not. That was not done.
That can be done along with the 65, now 63.
That was not done.
That is the problem.
That if I miss the bus, then it's not in my control.
Yes.
But only thing, this exhibit, so far exhibit F is concerned, there is an acknowledgement letter in which records this.
It is there. It is also there. It is your letter also only.
It talks about a letter. This
Yes.
is perhaps an email.
No.
Different nature of correspondence.
It is your letter only, not by him.
No,
if it is there, his letter, then it can be
I know
assumed.
65 is I am the author is from my email ID. তোমাকে না একে প্রশ্ন করলাম তোমার witness কে আবার আনতে হবে you to recall the witness and then bring it if it is true.
I don't know.
I'm ready to go to.
রোজ আসছে
So this is Australia.
This is Australia.
I'm ready.
The witness is in
The
Sydney.
court also can go.
Yes.
Commissioner.
No, the court also can.
Court also. I'll ask him to come.
Yes, next.
Come. Yes. But can this be marked as a marked for identification? যাতে এবার দিয়ে তাহলে মিনিটসটা ফিরে যাই। So after the objections raised by the plaintiff with regard to the selling of the property to the to defendant number one, what steps did you take?
I had sold the property.
Sold the property. So I take it that in spite of the objection,
Before the objection.
Raised by the owner, you sold the property.
Before the objection.
Before the objection. Why didn't you reply to the email of 11th May 2010?
I have no recollection of the email.
Will you be in a position to look into your inbox?
Not immediately.
Chirodeep, the same email ID, Chirodeep B.
Not immediately.
Why?
Not immediately.
Why?
I am otherwise disposed.
What do you mean by that?
I'm busy.
You are more busy than deposing before this honorable court.
No, I am deposing in front of the honorable court. I was talking about looking into my inbox.
Yes, I'm
not
asking.
about being here.
Is he here?
Now is not.
I understood. If a liberty is granted to you by the honorable court to look into your email now, will you be in a position to look for this email dated 11th May 2010?
I think the Lordship understands that it might take a little bit of time. The Lordship will understand that it will take a little bit of time because it's 2010.
If that time is given to you,
I leave it to the Lordship.
No, this has to be done. He has to look into this email ID. And so, because this other option, and once the witness is here, I can show it's very easy to delete it, even if it is there. To find it out from the inbox,
If you delete it, your mail will be there. Sent item also there.
No, that can be. Now, to search an email takes not even 10 seconds.
Correct.
To search an email, even if it is 5 years old, not even takes 10 seconds. So I just put this question to you. To search an email, however old it is.
He's not the expert.
He's
telling that he will bring.
document.
He's telling that he will produce.
No, that he has not said.
What is the last answer?
No, that he has not said.
Will you be able to produce your email on what is the date?
Sir, I will definitely go through it.
Yes.
ठीक है. But may I close to the meals? 15 minutes is left for the other matters, man.
Yes.
I have told the truth for this.
How much time you will take? What is the matter?
Yeah, the matter is, my lord, I am the owner of a property in SN Banerjee Road, 13 katas of land. I gave it to him for develop the property. Now this first floor, second floor, the property is there. He has built the property. He has met the 6th stories. The construction is more or less done. The construction is more or less done, I know. Now the difficulty
Construction is over.
There is no
What is the dispute now?
dispute is there is no CC. There is no completion certificate. This is number one. Now, what he has done, without handing over possession to us, he has sold this portion.
Who are you?
I'm the owner.
Okay.
I'm the landowner. There's 13 katas of land in SN Banerjee Road. I'm the landowner. Now, without handing over possession to me, portions of this property has now been sold to different number one. Now, here I have two things. First is the first floor is commercial. They have no problem. He has sold 50%, 50% is over, 50% money should come to me. He has not given it to me. But so far the second floor is concerned, which is a residential has been sold to this United Vein Care, who has now made a laboratory over there. And then they have converted to a commercial with Kolkata Municipal Corporation without completion certificate. And now what happens? A corporation tax, and then he was supposed to pay KMC tax till the construction period. A corporation tax which is 750 per quarter, it has gone up to 50,000 per quarter. And then I have to pay it because it's my property. So it is, that is not even the subject matter of the suit. So, and
what is the prayer in the
suit? Prayer in the suit is say, and I say, the power of attorney on the strength of which he has sold the property did not give him the authority to sell the property. So the power, there is no right on the long power. and short of the matter. He did not have the power to sell the property.
Climbing the trees.
Please stop them.
No, date has not been.
Lord, my lord is fixing.
So offering for the plaintiff, so offering for the defendant. Defendant witness, no? Defendant witness is present. Cross-examination resume.
No, the witness of the defendant.
Defendant number 2.
Defendant number 2 witness is present. Cross-examination resumed. But after some cross-examination, counsel for the plaintiff prays for time. Accordingly, cross-examination is deferred. Let the matter appear on 28 March at 2 p.m.
Well,
wait.
Yes, next.
I am for defendant number. Defendant, my lord.
Morning.
Well, this is my application, my lord. Suit is for recovery of money for my lord.
You are for the plaintiff?
For the plaintiff, my lord.
Yeah.
I have taken the suit is for recovery of money. I had given him 25 crores loan because he wanted.
What is the stage of the suit?
When I've instituted the suit, I have found out that he is about to sell off his properties. I have made this application, my lord, for him to furnish security to ensure that my decree, if I get it, is not a paper decree.
But I am yet to, my lord, file my wakalatnama and board of resolution, my lord. But I'll have it filed, my lord, in the course of the day, my lord.
My lord?
Writ of summons issued?
Well, summons has not been lodged, my lord. I believe, my lord, immediately after institution of the suit.
No, it has gone to the warning list. You are not appeared.
Yes,
they have taken some application out, my lord, for furnishing.
May I only indicate this?
The matter was listed on 6th November, none appeared. Then matter was listed on 11th December.
Yes,
then warning list. Now it is appearing today.
I received the brief last week, my lord. My lord will kindly condone that. I have, my lord, filed. May I file the affidavit of service? I have already given him a copy of the application. Today, my lord, I am only seeking prayer. I have made a prayer for attachment before judgment as well as for, my lord, furnishing of security. There is an agreement recording that I have given him money. There I have enclosed bank statements which start from page number 26. The defendant has also, my lord, annexed, has issued balance confirmations in my favor, which starts from page 92.
Correct. Now let the file affidavit. Let the file affidavit.
My lord, my only apprehension is let them say that they are not going to sell off those properties, or let at least some sort of an.
You are not appeared so many dates. Now the matter is listed. Now you are telling that the security is to be given.
Because, my lord, even in the demand notice, in reply to the demand notice, they have admitted.
So
they wanted some time.
If you have to be serious in contesting the suit, proceeding with the suit, why you have not appeared in 6th November, 11 December? After warning list, the matter is listed today.
I understand that, my lord. But that should not give them a liberty to file an affidavit. They have not stated one word.
I will not file affidavit. I am fixing tomorrow.
Tomorrow, my lord, I have some difficulty, my lord. Friday, my lord.
Friday. Without affidavit.
Without affidavit. My lord, my instruction is very simple, my lord, that we do not have anything to furnish any security. We don't have the means to furnish any security. So if your lordship finds that they have a prima facie case,
court will create the means.
My lord.
This court is having so many power to create the means for the security. If the security is not with
that is my instructions, my lord. Whatever your lordship, whatever your lordship says, my lord.
If my lord takes judicial notice of that submission order 38 rule 6
suffering for the plaintiff, suffering for the defendant. Full stop. The plaintiff has filed an application being J1 of 2024, praying for direction upon the defendant to secure an amount of rupees, furnishing security to the tune of rupees 25 lakhs, 25 crores, 88 lakhs, 22,596. Full stop. This court finds that before passing any order, an opportunity should be given to the defendant. Accordingly, defendant is directed to show cause within
A short period we
within 10 days from today as to why an order shall not be passed for securing an amount of rupees 28 crore 25 crore 88 lakhs 22,596 in terms of prayer A of the present application.
Would it be a lordship's pleasure, my lord, for me to file an affidavit?
Full stop. Let the, are you given the show cause?
Chocos
Let the matter appear on.
Very
आज
well.
कितना तारीख है 12 है. Let the matter appear on 26 February.
Great.
I'm grateful to my lord.
My application.
Yes.
My lord, this is an application in respect of a trust, private trust. If your lordship kindly take, my lord, the application, the cause title first, so that I can explain the facts shortly. The petitioners 1, 2, 3 are the three trustees of Pradeep Estate Trust. They have the office, my lord, within jurisdiction, and number 1 and 2 respondents, they are other two trustees. So there are 5 trustees. And my lord, the respondents reside in Mumbai. Certain my lord, litigations are pending in Mumbai, but the problem is, in short, may I just tell you, then I shall show my lord the pleadings and etc. My lord, there are several properties in Kolkata, and my lord, rents are collected for the purpose of, my lord, I should say, administration of the trust. Several bank accounts are there. I have given the particulars. The 2 respondent trustees have written letters to the banks not to allow us to, my lord, operate bank accounts. So, my lord, as a result thereof, my lord, the expenses, I have given what nature of expenses are to be borne, that I can't, my lord, spend any money. So, in this context, may I just go to the prayers first, then kindly come to the prayers first. Kindly take the prayers for the time being, my lord. Prayer A, that should be, my lord, for the final. B also same thing. C and D, particularly D if possible, as interim measure, kindly allow us to either operate the existing bank accounts or, my lord, make another new account so that I can operate it. Kindly come, my lord, to the details of the properties. Your lordship kindly take, my lord, paragraph 17.
So now who is operating the bank account?
Nobody, because
My lord, I am application. My lord, I am opposing the application. The facts as stated by Mr. Ghosh are perhaps not correct. I would like to put it on affidavit.
May I complete my submission?
No,
May
Mr. Ghosh has not yet completed. Let.
May I complete the facts first? My lord, in short, my lord, paragraph 11, may I just point out the, my lord, paragraph 11. The present trustees named are as follows. I'm just indicating to your lordship.
Yes.
Then, paragraph 12, subject matter of the trust. Kolkata properties who are occupying the same. Then, my lord, Mumbai properties who are occupying the same. All are, my lord, there. And movable properties are in Schedule E, which is at, my lord, page 96. Now, paragraph 14, the respondent number 1 and 2 reside in Mumbai. I pointed out to your lordship. Necessary pleadings are there. Then paragraph 15, the said trust has since been functioning under the management of all the trustees. So prior to this problem, if I may use the expression quote unquote problem, 5 trustees were operating. There are some resolutions taken. Milord, paragraph 16, I have quoted that. Regarding Milord disposal of the properties in possession. Then Milord, paragraph 17, Milord, these are the present Milord occupants or the tenants. All are mentioned there. Now the kindly come, Milord, to paragraph 29. These are the letters, Milord, mentioned, which are annexed regarding the operation of bank account. Freezing, they asked for freezing of the bank account, and we asked the otherwise. Now kindly come, Milord, to paragraph 31. This is the practical problem at page 23. These are the various bank accounts, Milord, which are being operated, which were being operated. Now, 22nd May 2023, Milord, is started, and Milord, letters have been pleaded, and Milord, we also requested the bank. Kindly come to paragraph 49. These are the payments which are to be made. First one, kindly ignore, Milord, the 74, which is their statutory payments. Paragraph 49. Paragraph 49, there are subheadings. Number 1 is statutory payment, and number 2 is expenditure outgoings.
Yes.
So these are to be paid. For payment of this, Milord, on these accounts, the petitioner trustees have made this application for the time being, so that after affidavit, other prayers may be considered. At least allow us to, Milord, operate the existing bank account. I can give accounts. Of course, I am liable to give accounts as a trustee, and or open a new account, deposit the rent therein. We'll have to pay the statutory payments, the expenditures otherwise mentioned in such and such. And Milord, for that purpose, Milord, we made this application. Allegation, counter allegation, letters, counter letters, those are there.
Why this problem has occurred? Why they are refraining you for operating the bank account?
That, Milord, 2017 there was that resolution is there, and Milord, there is, I have stated so, Milord, in the application. In respect of Mumbai property, they have transferred the property flats in their name. Relating the same, some suits are pending there, filed by us against them, not in relation to this bank account. So I have not, though I have pleaded, I have not claimed anything regarding, Milord, the suit. Any pleading, nothing is, Milord, common here, except the amendments made in the application. So far as the Milord, the Kolkata properties are concerned, and the rent collected from there, or to be collected and deposited in bank account, the petitioner trustees are helpless. The statutory payment have to be made, particularly, Milord, at the risk of repetition.
Since when it is not being paying?
23 it started, to be frank, very frank.
Yes. Any notice issued by the authorities with regard to the non-payment of property?
We have paid, Milord, I am told, from our own pockets. Just to be, otherwise, Milord, many statutory payments have to be made. Then we will be defaulters as trustees. That we have been paying. That will be the subject matter of, Milord, the accounts of the trust. But now it becomes, my lord, burdensome.
How the rent has been collected? Who is collecting the rent?
My lord, rent is not being. We are making the statutory payments from our own pocket.
No. So
No
what about
rent
the
is
what
being-
about the rent
It is not being deposited there.
since 2023? Since 2023.
That's I'm told.
Yes, Mr. Ghosh.
My lord. My lord, I think the correct facts have not been placed before your lordship. Firstly, my lord, we had to write to the banks for debit fees because, my lord, there were several fixed deposits in the name of the trust. These fixed deposits were encashed by the plaintiff, by the applicants before your lordship and appropriated. That's one. Two, with regards to the statutory payments, my lord, what has not been indicated to your lordship, that's all throughout.
So how soon you will file the reply affidavit?
My lord, within 2 weeks, my lord, we'll file it. It's a matter which has been pending since 2017. It's not something which has happened yesterday.
Okay, whatever it may be. Now, with regard to how soon? Within 10
2
days, you
weeks. 10 days, I'll file it. 10 days, I'll file it.
When the affidavit of service is here.
So appearing for the plaintiff. So appearing for the petitioners. So appearing for the respondents. Full stop. Petitioners have filed an application. Any application is filed? No.
This is the application.
Petitioners of
Under Trust Act.
Petitioners operate for interim order. Full counsel for the respondent pays for time to file affidavit in opposition. Let affidavit in opposition filed within 10 days, reply if any there to be filed within a week thereafter. List the matter. List the matter on 5th of March 2020.
5th of March.
May I my vocalatnama on behalf of affidavit of service filed in the department. Affidavit of service filed by the plaintiff be kept with the petitioner be kept with the
Grateful.
जाने दो.
I appear for the defendant number 3. The plaintiff's witness had been recalled. He gave his chief again, and I'll have to cross-examine.
Recall?
Because when it was the original chief and cross was done, my lord, we had no notice. So we made an application. That opportunity has been given to us to recross. Only one thing, my lord, that after that, there was a direction, I'm told, that issues should have been framed, or this additional issue. So my learned additional issue, if any required to be framed, shall be done once the suit appears. This is the order of 20th February.
I think last occasion it hasn't done.
I thought the issues were done. We have our suggested issues. I don't
last
know.
occasion I had done, I think.
It's in an order.
Yes, order dated
Oh, then I'm grateful.
12th December.
That's it. Just struck me that because I had the suggested issues. It's got it.
That are taken into consideration.
Then I'll start.
Suggested, you have given the 2 suggested issues. I have reframed the total issues by 12th December.
I'm grateful. I'm
12th
sorry.
December.
Yeah. It
Huh? I don't know if it is over. I don't know. I don't know.
Don't know. Give me his deposition. Good deposition. Yeah. No, I'll continue till 3:30. I'll try and finish. But your lordship has kept it also tomorrow. And so I have some difficulty tomorrow at 3 o'clock. Only that.
Tomorrow not be there.
Only tomorrow.
Okay, let it come.
Without Kumar Poddar.
Hmm.
Kumar Poddar.
Slowly, okay?
Yeah, cross examination, na?
Yes.
Cross examination on recall.
INOD.
BINOD.
ABC হবে
Cross-examination of plaintiff witness number 1 on recall.
This exhibit has gone down. The last exhibit is exhibit 3, but the first two were A, B. So it should have been C.
क्या हुआ देखो?
Anyway, that is already marked. I'll start.
Dependent ABC उल्टा हो गया.
Mr. Poddar, do you have a passport?
Yes, Your Honor.
Honor, you don't have to say. Just yes. Now, in your passport, which address of yours has been recorded? Because you have stated that you reside in Hyderabad as well as in Calcutta.
In my passport, my address is given in Hyderabad.
As Hyderabad.
Yes, other matter release.
Now, can I take it that you are aware that before the issuance of the passport or renewal, confirming your residential address, there would have been some sort of verification by the authorities?
Your Honor, I would not know.
Was there any police verification of your address before the issuance of your passport?
I do not know.
But would you agree with me that the address referred to in your passport is your genuine address?
Yes,
genuine
yes,
residential address?
Yes.
Yes. Now. In your deposition, you have referred to a conveyance dated, no, what 98? 19th of February, 1998, being exhibit A.
That is correct.
No, I'll just.
Exhibit A then.
Comma. Now, please tell my lord whether you had anything to do with the execution of this conveyance.
I was present over
Have a
there.
look at it first.
I was present over there. I was present over there.
Where were you present?
In the registrar where a deed of conveyance was being done. I don't remember the place.
Wait a minute. Exhibit a document.
Manav, that is exhibit 2, and in brackets you can write question 13. Is your name recorded anywhere on the registered document which I have shown?
No, Your Honor.
Slowly, we'll go in one more.
I'm sorry. I'm sorry.
Recorded on the registered document I have just shown you.
No, Your Honor.
You say no, my lord, or don't say anything. Just say no.
Okay, okay. It's okay. No problem.
I thought I was referring to
I know,
the
so
law.
okay.
That's why I was saying no, Your Honor.
Okay, it doesn't
I'm
matter.
sorry.
No. Were you a director of the plaintiff company in 1980? In 1998, when this document was executed?
I became a director in 98. I don't remember which month.
When you were present, in what capacity were you present? When this document was executed at the registrar's office, as you have deposed.
Because I am also a shareholder of this company.
In this document, reference has been made to an agreement for sale dated 1st December 1980. Has the plaintiff disclosed that document in this proceeding?
I'm not aware.
Please, Mr. Draper.
Are you aware?
Just a minute.
Oh. Are you aware of any such document at all?
Yes, agreement had been done.
Can you tell my lord with whom the plaintiff had entered into such agreement in 1980? Agreement for sale in 1980?
I do not remember.
So, hello. I do not remember. So can I take it that you had no personal interaction with the owners of the properties in 1980, the owners of the property in 1980?
Your Honor, the owners were living in London and their representative was here, and I had interaction with the representative over here.
And who was the representative?
I think it was Mr. Sadka.
Sadka.
Sadka, if I remember correctly. Sadka.
Would the plaintiff be in possession of the agreement for sale dated 1st December 1980, which is referred to in this conveyance?
I would not know where it is there.
Can you tell my lord when the plaintiff took possession of 87 Park Street, the premises?
We took
87 Park Street.
We took possession of this property in February 1998.
So can I take it that the plaintiff was never in possession of the property prior to February 1998?
That would not be correct. It was being handled by our office. I would not remember.
I'm drawing your attention, document tag. I'm drawing your attention to clause K at page. At internal page 10 of the conveyance. K, choto a, K small a. Is it a fact, and or are you aware that it is stated that the purchaser is, inverted commas, the purchaser is already in complete possession of the suit property, inverted commas close, suit property ... since the year 1980, inverted commas close. Are you aware of this, or is it a fact?
I would not remember.
Now, on the last occasion, you had exhibited a document marked Exhibit 3, which appears to be a letter dated 31st October 2019. Can you confirm to my lord that this document I am showing you is an original document which was returned to the plaintiff by the postal authorities?
Your Honor,
okay.
We had given this document one by hand through my authorized officer, Shabd Kumar Chaudhary, who had gone over there and gave the letter over there. Some staff of Mr. Dobal Sen, Mr. Dobal Sen took the letter and returned it back to him. We had also sent another letter by speed post, which had been returned back, not accepted.
The document I have shown you is the document that was returned by via speed post. Am I correct?
Yes, Your Honor.
And where is the document that was purportedly hand delivered and returned?
The document,
the original of the document. Sorry, original of the document that was purportedly given and returned.
We should be have that. This should be in our office.
In our office.
Therefore, I put it to you that this letter dated 31st October 2019 was in fact never received by the defendant number 3, Dr. Debal Sen.
I beg to disagree.
Both the originals are with the plaintiff. You have just confirmed that, have you not?
I have. I'm sorry. I said only the letter which we had given, handwritten, which was delivered to the over there. One of the staff member had taken the letter and gave back a signed copy to us. The other original letter is returned by the street course, so it cannot be with the plaintiff.
Mr. Poddar, is it your evidence you gave 2 copies were hand delivered to Mr. Sen and 1 was returned? Or was it 1 copy given and that was returned after
the second copy was returned?
So it is your evidence that 2 copies were sought to be hand delivered and 1 by speed post.
Your Honor, we said that we had given 2 letters by hand. One was taken by the staff of Mr. Dobal Sen, and the second copy was returned to us.
Second copy was returned to us. Yes, second copy was
returned to us.
Have you produced the second copy which was returned to you?
I am not sure.
I put it to you that till date you have not produced any document purportedly received by Dr. Sen and or his staff, as you have earlier deposed, as you have just deposed.
I have got to check up with my advocate whether it has been presented or not. I would not be aware whether it has been given or not. But the copy which was returned back from the courier, speed post, has been produced in the court.
Did you have anything to do with the preparation of this document being Exhibit 3?
The legal people will be doing that.
So if you did not have anything to do with this document, I put it to you that you are not in a position to authenticate the veracity of the statements made therein.
I beg to disagree.
Now, please come to this document. You have referred to, the plaintiff has referred to flat number 87E. Is it your evidence that the flats in the in the property in question are all numbered separately?
We have been given record of different flats along with this over there.
Is there a flat 87? Are there 87 flats in the property 87 Park Street?
There are a number of flats.
Are there 87 flats in the property 87 Park Street?
No, sir, there are not 87 flats. Different flat. The number of the building is 87, and there are different flats in the building. It doesn't have 87 flats.
I put it to you, there is no flat bearing inverted commas a flat number 87E in the premises 87 Park Street. What do you say?
I beg to disagree.
From which record do you find that there is a separate flat number for each flat in the premises?
In the list of flats given to us, along with this thing, numbers of all the flats are given.
This thing.
This thing. Along
with this.
Along with the sale date.
This thing, in bracket, sale date.
Did the plaintiff ever verify the occupants of the list of flats that you are talking about?
We have accepted the list as given to us by the seller.
I put it to you that no such list has been exhibited by you in this proceedings as of now.
I have got to check up. I cannot say without verifying.
I further put it to you that you personally will not be in a position to verify the contents, the correctness of the contents of any such alleged list.
I beg to disagree.
Mr. Poddar, this list was prepared by a third party before being given to you. You stated that you do not know whether it was verified at the time in 1998. How do you propose to substantiate such alleged?
I have never said that. I have never said that. Kindly repeat your question, please.
It's a long question. Hear it. There's no.
How do you propose to substantiate such list?
Your Honor, the representative of the seller was there, and
representative of seller were there,
and he has given the list at that time.
Please come to the schedule of the conveyance being Exhibit A at internal page 13. No, conveyance, no? Where's the conveyance? Conveyance will also have.
Exhibit 2.
Exhibit, oh, I'm sorry, 2. I made the mistake. The schedule. Has to be a schedule. At internal page 18, sorry. No, or rather, it begins at page 17. At internal page 17. এটা তো তুমি দেখালে ভুলটা দেখালে ঠিক আছে পছন্দ does this schedule mention the flat numbers of the different flats?
Your Honor,
such as 87E.
Your Honor, page 18 says municipal premises number 87A, 87B, 87D, 87E, 87F, 87G, 87H, 87J, 87K, and 87L.
L.
Now, is it your evidence that the municipal premises numbers are equivalent to flat numbers?
These are the flats over there, which which has been mentioned in the schedule.
Can I take it that the schedule of this conveyance clarifies that the premises 87A to 87L are separate from the municipal premises number 87 Park Street?
I beg to disagree. These are flats on 87 Park Street.
Have you disclosed separate municipal assessment orders or bills in respect of each of these municipal premises 87A to 87L before this court, before this honorable court?
I am not sure.
Is it, I'm asking you again, is it your evidence that all these premises are a part of 87 Park Street, or are they separate?
They are all part of 87 Park Street.
So any flat in the premises would be a part of 87, the municipal premises number 87 Park Street, as well as a separate municipal number 87A, B, etc. Am I correct?
I think so.
I put it to you that the schedule to the conveyance as well as to the in the plaint do not refer to the portion in occupation of the defendant number 3.
I beg to disagree.
Now please come back to exhibit 3. The plaintiff has written inverted commas, as per our records, ... inverted commas close. What records is the plaintiff referring to, according to you?
This is the record as given to us by the representative of Mr. Craig, given to us. Mr. Craig, C-R-A-I-G. C-R-A, C for Calcutta.
Craig.
It is stated that one Mr. O.P. Puri no more resides in the portion occupied by the defendant number 3. Where does Mr. O.P. Puri reside? Now, where did Mr. O.P. Puri reside?
Mr. O.P. Puri is no more, and there were couple of flats given to Mr. O.P. Puri and Mr. Joshua. And in which flat, who was living, I would not.
In which flat?
Who was living, I have not checked.
When did Mr. O.P. Puri pass away?
We came to know about the death.
When did Mr. O.P. Puri die?
We have never been informed when Mr. O.P. Puri died. We only came to know in 2019 that Mr. O.P. Puri and Mr. Joshua have passed away, and then we stopped receiving rent from their family members.
Have you made any further inquiries to find out when Mr. Joshua or Mr. Puri died?
I tried to find out, and I came to learn later that they died somewhere around 2002.
Somewhere around 2002.
Now, have you, Mr. Poddar, personally visited the portion presently in occupation of the defendant number 3?
I have been visiting it from outside. I have never visited any tenant's flat unless if somebody has invited me over there.
Now, can you say that it is stated in your letter that this portion is occupied by, inverted commas, you along with your family members, inverted commas close. Can you tell, can you say before this honorable court, who are the family members of the defendant number 3?
Your Honor, I have not gone there, but I only know of Mr. Dobal Sen and Mrs. Dobal Sen, and their children are Mr. Dobal Sen, Mrs. Dobal Sen, and their children are illegally living in this flat.
Would I be correct to say that you have not made Mrs. Sen nor the children of Debal Sen parties to this suit? See the cost title.
I have made Mr. O.P. Puri, I have made Mr. Deepak Puri and the children and Mr. Dobal Sen as the party in the suit.
Please have a look at the cost title. Have you made the children party in the suit? As
I
you
have
just
not
stated.
I am not.
See the cost title.
I have not made. I have not made the children as party.
Just see, because you said incorrectly. Just answer. Oh.
That's all.
Well, only, no, I have some.
How much time it will take?
Hour it will take.
Hour?
I think so. I thought like it might not, but only tomorrow, my lord will excuse me. I'm sorry about it.
Please step down.
And my lord, since it's the end of the day, on Friday,
Your Honor, I've come from
my matter is for arguments. On Friday at 11, I was not aware. I had to leave. I'm leaving town tonight. I'm back on Friday.
Fix?
There's a CESC matter. That's for argument. It's fixed. It's the other side is not appearing. It's that defamation damages.
That one.
I just have to complete. I have to give my reply.
So you will not there on there.
And I'll be coming back.
Somebody mention, I will adjust.
In case your lordship wants to fit in another.
Honor, I've come from Hyderabad for this thing. May I request if an early date is given this week so that I can
This
go
week
back?
Won't happen, Mr. Pudha. I'm sorry.
Or early next week, Your Honor.
Anytime.
Because I've been coming for this every time, Your Honor, if you can help me.
Mr. Bush's fault.
How much you will take? You will take hour, an hour,
At least, my lord. I think the way it's going.
or I am fixing in the month of last week of the March.
Yeah.
So I will fix 2 dates so
Yes.
that the
Yes.
matter can be finished.
Because Mr. Bose will also cross-examine
Yes,
after.
Mr. Other party.
Your Honor, then kindly keep 2 days
That's why I'm
so
telling.
that Mr.
We'll finish.
That's why I'm fixing 2 dates, one hour, so that the examination can be completed. So you cannot. But it will fix in the month of March only.
Right.
I'm grateful.
So and so appearing for the plaintiff. So and so appearing for the defendant number 1 and 2. And so and so appearing for the defendant number 3. Plaintiff witness is present on recall. Police counsel for the defendant number 3. 3 has has started cross-examination, but due to paucity of time, cross-examination could not be completed. Accordingly, cross-examination accordingly, the same is deferred. Full stop. It is the matter is already also fixed tomorrow at 3 p.m. But the learned counsel for the defendant number 3 is having some personal difficulties and pray for adjournment. In view of the submission made by the counsel for the defendant number 3, hearing of this case on 13th of February 2025 is set, John. Let the matter appear on. First April and 2nd April at 2 p.m. 2 p.m.
May I have your lordships kindly, my lord, to mention, my lord, item number 83 of the monthly list.
All that, three suits. I think other two suits are mentioned there.
So all will come together because this is the last examination. Then argument will start.
But item number 83 of the monthly list, my lord, the interim order is due to expire today. So this is the last order that has been passed by your lordship.
And for the dependent number 3, led by Mr. Tar. The respondent number 1, led by Mr.
Bajoria.
This is, my lord, that partition suit. The lordship had passed, my lord, an ad interim order that has been extended, my lord, from time to time. My lord, I will just pray for.
What is the stage of the suit?
This,
Parties are exchanging affidavits.
in the suit, my lord, they have not filed the written statement as of now.
Writ of summons served.
Yes,
But we have.
You have not filed the affidavit, written statement. I filed application.
Before the master learned master, we have taken steps.
Sons appearing for the plaintiff. Sons appearing for the defendant number 1.
I am for the 3.
Defendant number 1. Defendant number 1. Sons appearing for the defendant number 2. And sons appearing for the defendant number 3. Counsel for the defendant plaintiff submitted the interim order granted earlier is going to be expired today and prayed for an extension of interim order. Considering the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 5th of March 2025 or until further order, whichever is earlier. Let the matter be remain in the list.
Lord, one more indulgence from your lordship, my lord. In the meanwhile, my lord, as regards the application, my lord, pleadings have been completed. My lord, subsequently, one document has been disclosed by the defendant number 2. But I will just bring that before your lordship by way of a supplementary affidavit.
Bring on that.
Very well, very well. I'll bring.
Item number which was there listed at 345. Item number 23, your lordship.
345.
Yes, your lordship. Today was fixed at 345. Unfortunately, may I suitable be the date be given? May other side is here. I'm mentioning about notice.
Who is for the other side?
I'm for the defendant.
For argument?
Yes, I was supposed to conclude my arguments.
I have also filed one application. Yesterday, I was talking about regarding the signature, testimony of signature. That application filed.
Already filed?
Yes.
Record. Sons appearing for the plaintiff. Item number 23. Sons appearing for the plaintiff. Sons appearing for the defendant. Though the matter is specially fixed today at 3:45 p.m. for argument, but due to the bar resolution, the matter could not be taken up for hearing. Accordingly, the case is adjourned. Let the matter appear 28th of March 2024 5 at 3 p.m.
Your lordship, item number 35, your lordship, the council
35 of
today's list, your lordship, the council.
Non-commercial?
Yes, your lordship, non-commercial. Your lordship, the council appearing is an outstation council. If your lordship can kindly fix a time next week, Thursday, your lordship.
For what?
New motion, it's an injunction application, your lordship.
Injunction application? Yes. It will be listed already on the list.
The council is an outstation council from Delhi, your lordship. Kindly next Thursday, your lordship. Anytime convenient, your lordship.
Speak, my lord. We have some difficulties, my lord. Your lordship, kindly.
Every day this court is having difficulty.
If your lordship could kindly fix a time.
Time I can't. Time I will give in the month of April first week.
Lordship, kindly, your lordship.
I can only fix at the top. Which
Yes,
date your senior is coming?
Thursday next week.
Thursday, 20th.
28, I have some difficulties. Mr.
20.
Chatterjee is leading me in this matter.
Who?
Mr. Aniruddha Chatterjee.
Aniruddha Chatterjee.
Leading me in this matter, my lord. On 28th, some difficulties, my lordship, kindly.
28?
Yes.
20, you want 28?
20, yes.
20.
20.
20.
Next Thursday.
Yeah, I have to take instruction about whether 20, some difficulties.
Okay, you're there the petition. Let the complete first.
Yes,
My lordship.
March, my lord. It will be.
No, your lordship, it's an injunction application. There is some urgency, your lordship.
May I, my lordships, kind leave to mention a matter, my lord. My lord, this is a
35.
commercial suit, my lord. My lord, I'm seeking leave to deposit the court fee, my lord. My lord, if your lordship may kindly take up the cost papers, my lord.
When you filed the suit?
My lord, the suit was filed on the 29th of January 2025, my lord. Subsequently, the matter has come up on February 7th, my lord, when the plaint was admitted, my lord. However, my lord, the department is insisting that since the court fee was paid online, my lord, that a copy of the challan be filed with the department, my lord. However, my lord, since it has been filed online, my lord, there is no physical challan, my lord. I have the physical copy of it, my lord. However, my lord, I have to seek leave, my lord, of the court.
For
my lord,
what?
for depositing the court fee, my lord. The e-challan of the court fee, my lord.
So you're deposited.
Yes, my lord. The
So what do you
department
want?
is to accept it, my lord. The
So
department.
why we have
accept-
supplementary? You accept it.
Very well, my lord. I shall
Why
take
we have
instructions.
supplementary?
Very well.
Prepare supplementary. Come tomorrow. I will give the leave. It may file.
Very well.
That will be better.
Very well. Get free.
Favorite ही तो.
Has been fixed on, my lord, with regard to item number 35.
It's been fixed
Fixed on 20th, my lord.
20 at the top.
Grateful, your
We
lordship.
don't. No time at the top.
Very well.
Grateful, your lordship.